Yes.
My lord, the item number 46, may I take, my lord, the item may be taken up in the past or 230, my lord. I have
Item number?
46. Supplement.
You want these matters to be taken up? 45.
First of all, at 2, my lord, at 230, I have to, my lord.
The admission matters.
Or it may take on Monday or Tuesday.
We'll have it 30, 46, 47, adjourned till matter stands adjourned to 38, 2000.
Consider document item number 27. In this matter, the petitioner wishes to engage some other counsel, but he has not been able to come to me take the file since his son is admitted in the hospital. So he has gone to Mumbai. So may I pray that this matter be adjourned for 4 weeks so that we can take the file and engage some other counsel.
The request of the learned counsel for the petitioner matter stands adjourned for 2 weeks.
We have this lordship I beg to mention item number 19. If the petitioner doesn't want to press the matter further, we will be allowed to withdraw the. If the petitioner doesn't want to press the matter further.
You want to withdraw?
Withdraw, Lord. I am put on record.
The learned counsel appearing on behalf of the petitioner submits that he has instructions from the petitioner to withdraw the instant writ petition, for which the instant writ petition stands closed on withdrawal. Mr. Kolika, you know, this court doesn't put the name. And you give it, it will be given out there, no?
Please, Lordship, I beg to mention item number 36 of daily list. The matter has become infructuous and the petitioner said he doesn't want to contest the case anymore.
You got the money? Whatever, what is this?
The order has been complied with.
Order dated?
17/7. 12/2 of 2021.
In
WPC number 363 of 2021.
the learned counsel for the petitioner submits that the order dated so-and-so, passed in WPC number so-and-so, has already been complied with and as such would not, has been complied with. Taking into account the above, the instant contempt proceeding stands closed.
Obliged.
My lord, I beg to mention item number 11, Lord. As the MD's counsel is not well to the Lordship.
Who?
And its mother of the Lord.
What about the others? Stay, interim order,
Interim order, Lord.
there.
Lordship, he is supposed to do the, yes, sir, he is supposed to do the admission. Lordship.
Whether there is an interim order or not.
There is an interim order, Lordship. Interim order 30/2021. Interim may be complete.
You do the matter.
Daily list item number 1.
Yes. What is he asking for? Yes, Mr. Counsel, what are you asking?
Enhancement.
Huh?
Enhancement.
And text. Where is the you filed an arbitration petition?
Yeah.
The arbitration petition, what is the direction passed?
By the divisional commissioner, he is the arbitrator appointed by the central government.
Order dated 29th of August 2014.
Order is case number 29.
Yes,
29.
and that has not been complied with,
Yes, yes.
not complied with.
Yes.
Yes,
And it is also
Mr.
not to be
Burua?
concerned for her
my lord.
matter.
Huh?
Because there are some similar cases, already Honorable High Court has passed the order.
Oh.
And those orders, they have complained, some of them. But it's pending.
Oh. In this regard, we have filed affidavit.
Hmm.
My lord. We have filed affidavit stating that because the direction was to competent to land acquisition. That we have clearly said until and unless it's been again reassessed by the competent authority. Being NSA authority, I cannot do so. It is also admitted that similar cases which have learned friend mentioned, in that two cases we have paid because that as per that order, Allah has assessed and reassessed and given to us. But here we have clearly stated in our affidavit paragraph 8 and paragraph 9, stating that until and unless competent authority land acquisition reassess the method.
so your only problem is that a competent authority needs to reassess.
Yes.
Who is the
competent
competent
authority,
authority?
yes. It is a ADC.
It is a
You have
is
issued,
effective.
this is a notification under 3A.
Yes.
Whom have you appointed?
No, Tala is not appointed. It is by ADC. Kamrup was the Tala. We appointed arbitrator earlier.
Who is the competent authority?
Additional Deputy Commissioner Kamrup.
And they are to reassess.
Yes.
Then you are going to pay.
Then they after it to submit it to us, then we'll pay.
Huh?
Sometime we have received the communication.
No, this is an order passed on to the 29
Yes, sir.
8/2014. And you still require,
We have got it, received a letter on 4 August 23 recently
from whom?
from additional deputy commissioner.
What does it say?
He says he required some more time.
No, no, is the government of Assam going to pay from their own pocket? No, I'm asking you. Because here, there's already a direction passed under 3A,
Yes.
3G. Once the order is being passed under 3G, then you are to, being the competent authority, you are required to do it.
Yes,
Why you have not done it till now? Who is going to pay? Because this is not only a
Yes.
case of the amount being increased.
yes, Lord.
There will be an accompanying interest. Isn't it? Interest will be there. Who is going to pay? Then you are happy to pay after such a long time.
No, happy.
Because you have not challenged this order.
Yes. Because
Under 30, this order, you have not challenged it.
that was not challenged. That was not challenged because that similar order was used to comply. So now we are waiting. This Tala has to assess 3 assessments. Until unless you
And
do
how
it,
much time does it take
1
for
month.
this?
Time they
What?
required 1 month time.
No, no. No, no. You are to assess and submit the details before this court on 8th of September. 8th of September, ask your ADC to do. And else if it is not done, all interests will be borne by the ADC from his own pocket. Okay? Because otherwise you are penalizing, because of your laxity, you are penalizing the NHI. Because NHI tomorrow has to pay because they have not challenged this order. Then?
Yes.
Therefore, the instant writ petition has been filed by the petitioner seeking a direction upon the concerned respondent authorities to expedite the matter of compensation, payment of compensation in terms with the direction specified in the order dated 29/9/2014, passed in case number RR 61/2012 by the Commissioner, Lower Assam Division, Guwahati. Full stop. This court finds it relevant to observe that the order dated 29/8/2014 was passed is an award passed by the arbitrator under section 3G of the National Highways Act 1956. The said award has, however, not been challenged by the NHAI. Full stop. The delay in computing by the competent authority in terms with the award dated 29/8/2014 would seriously affect and prejudice the NHAI authority, as there would be further interest accrued on the enhanced amount. Under such circumstances, the competent authority, who is the ADC Kamrup Metro, is directed to
Rural.
Not met.
Huh?
Metro nine. Yeah.
Kamrup.
Oh,
Kamrup Rural,
Yes.
is directed to place before this court on place before this court by way of an affidavit the instructions, the computation pursuant to the order dated 29/8/2014 on 8th of September 2023. List the matter again on 8th of September 2023. It is observed, if that there is any further delay, this court shall take pass appropriate orders as regards appropriate or pass appropriate orders against the competent authority.
Okay, great.
Ms. S. Borua, appearing on behalf of the ADC Kamrup Rural, shall inform the authority about the order so passed.
I'm for Aswana 2, my lord.
You give your name. It is not fine.
At number 41 to 43, part third.
43 will lead, my lord. 43 be taken up. It's practically, my lord.
Yes, Mr. Chaudhary.
Yes,
I remember quorum.
yes, yes.
Subsequent
Quorum,
being
quorum,
adjourned.
quorum. My lord will kindly take the act.
Yes.
My lord, I'll place this scheme. I'll not take very long.
Hmm.
First, my lord will kindly come to section 32.
Yes.
The board may at any time call a general meeting of the members of the cooperative society. However, one general meeting in every cooperative year must be convened by the board. And my lord will kindly come to subsection 4 of section 33.
Hmm.
Any meeting of the General Assembly other than the special general meeting may, with the consent of the majority of the members present, be adjourned from time to time to a later hour on the same day or to other date as may be provided in the bylaw. But no business other than the leftover at the adjourned meeting shall be transacted at the next meeting. Then my lord will kindly come to section 34. Subsection 1, my lord, it prescribes what is the quorum.
Hmm.
Then please come to subsection 2.
Hmm.
If within 1 hour from the date fixed for meeting of a general assembly,
Within 1 hour from the time, not
yes,
date.
yeah, sorry, my lord, from the time fixed for a meeting of the general assembly, a quorum is not present, the meeting shall stand adjourned ordinarily to the same day in the next week at the same time and place. But the chairman of the meeting may, however, decide to adjourn the meeting to a later date, not later than 15 days or as the case may be specified in the bylaw of the society. My lord, the proviso is very important, my lord. Provided that a meeting of this special general assembly called on requisition of the members under subsection 1 of section 33 shall not be adjourned but dissolved. My lord, except a requisition meeting, all other meeting will be dissolved. Sorry, will be adjourned. In case of a, my lord, special requisition meeting, it will get dissolved. Then 3, if at any time in a meeting there is no quorum, the presiding officer shall adjourn it to such time or date as it thinks fit and announce the same at once, and the business set down for the meeting shall be brought forward at the subsequent meeting, whether at such a meeting there is a quorum or not. Now, my lord, I will come to the implication of the word subsequent use. Essentially, it is also an adjourned meeting. Then, my lord, will kindly come to section 39. A general meeting to be termed as annual general meeting of a registered cooperative society shall be held at least once in every cooperative year within a period of 6 months from the close of the financial year to transact the business as provided in this act. The board shall automatically stand dissolved for not holding annual general meeting in accordance with the provisions of the act and bylaw within the 6 months from the expiry of the financial year. That means if once a general meeting is not held, my lord, within 30th September, then my lord, the board will get dissolved. Then my lord will kindly come to section 41, subsection 2. The election of directors to a board shall be conducted before the expiry of the term of the board, so as to ensure that newly elected members of the board assume office immediately on expiry of the office of the members of the outgoing board. Then my lord will kindly come to subsection 4. Where a board fails to arrange for holding election of the director or delegates, as the case may be, before expiry of the term of their office in accordance with the act and the bylaws, all directors shall cease to be directors on the expiry of the period as specified in section 42(1). Therefore, my lord, my humble understanding is the scheme of section 32, then my lord 39 and 41 envisages that there will be an annual general meeting once in every year and it must be held by 30th September. Otherwise, the consequences is the board will get dissolved. So this has as a relevance in my humble understanding, my lord, in trying to find out what is an adjourned meeting and what is a subsequent. Now, my lord, the issue is when a meeting is adjourned, what it does, my lord, it takes up the agenda which was originally fixed. It is only in case where it is adjourned sine die, my lord, a fresh agenda would be required and a fresh meeting would be required.
But is there any scheme of adjourning sine die?
Yes, my lord.
No.
It is there, my lord. The proviso to subsection 2 of section 34. Provided that a meeting of the special general assembly.
No, that is a requisition meeting.
Yes, requisition.
Requisition meeting is not sine die. The meeting is dissolved.
Dissolved.
So there is no sine die dissolved.
No, the issue is, my
Adjournment.
lord, okay, let us not bring that concept of sine die. Now, question is, my lord, dissolve and adjourn. Now, when the continuity is there, then it's a case of adjourn. When it is, my lord, dissolve means it has to be started afresh. Now, when continuity is there, my lord, then it is always in case of adjournment, and in which case there will be no quorum. Merely because in subsection 2 of section 34, my lord, no requirement of quorum is mentioned. My lord, therefore, The meeting which
No,
is
no, no,
envisaged,
doesn't say about quorum. Subsection 2 of section 34 does not say anything about the quorum.
in that-
No requirement of.
Yeah.
It is subsection 3
Huh.
of section 34
That-
which
no,
says.
in fact, that is what I'm saying, my lord.
Hmm.
Lordships will not make any distinction between subsection 2 and subsection 3 when it comes to what is the effect of an adjournment meeting. The reason is very simple, my lord. In both the situation, the agenda which is originally fixed, that will be pursued in the next. In fact, my lord, there is a division bench judgment of our High Court.
Yes.
What had happened in that case, that was of course under the 1949 Act. Now, the AGM was supposed to be held within, my lord,
Hmm.
31/10 of that particular year. Now, the meeting was held on, my lord, AGM was held on 27/10. But, my lord, because of lack of quorum, the matter was deferred. Eventually, my lord, the adjourned meeting was held after 31/10. Therefore, my lord, the registrar, invoking the provisions under the 49 Act, dissolved the board of directors. A challenge was made, my lord. Then when it was said, the meeting which was held on 16/11 in that particular case, it's a meeting, original meeting. Therefore, there is no question of quorum. Therefore, it continues to be same. Therefore, they made the requirement of section 32 of the Erstwhile Act, and therefore it cannot be
Let
said.
us see that.
Yes, yes. I brought that. My lord, 1994 1 GLR, page, my lord, 1. My lord, will kindly come to para 8 at page 4. Examining the facts, as your lordship's got it, my lord. Page 4. Examining the facts in the light of the provisions of Rule 24. My lord, Rule 24 under the 1948 Act is perimeter to section 34 of the 2007 Act. It is clear that AGM was convened on 27/10/92 and only 23 shareholders turned up, but the business could not be transacted for want of quorum. The meeting was adjourned till 6/11/92. On 6/11/92, the adjourned meeting was held and election was held. Adjourned meeting is continuation of the meeting held earlier. It is stated at page 41 of this so-and-so on the law and procedure practice of meeting that adjournment if bona fide is only a continuation of the meeting, and notice that was given.
Mr. Chaudhary, let us see the 1949 Act.
Yes.
Kamko.
এখন বলুন, sir.
Kindly read subsection 4 of section 24. Rule 24.
Yes,
Sub rule 4.
1 second.
Oh.
If at any time during a meeting of the General Assembly, attendance of the members fall below the quorum as prescribed below, the chairman of the meeting, on his attention being drawn to the fact or on his own initiative, may adjourn the meeting to such a date, time and place as he may think convenient, and the business to be transacted that the meeting shall be disposed of in usual manner at the adjourned meeting, even without a quorum. My lord, more or less, perimeter to subsection 3, my lord,
Can we say that
almost.
to be perimeter when the
Almost.
word used out there? Kindly see subsection
Not
4.
exactly, but my lord, purport is same.
If at any time during a meeting of the General Assembly,
Yes.
attendance of a member falls below the quorum as
Yes.
prescribed above, the
Ah.
chairman of the meeting, on his attention being drawn
Drawn
to the
to the
fact or in his initiative, may adjourn the meeting to such date,
Time and place,
time and place as he may think convenient,
and the
and the business to be transacted at the meeting shall be disposed of in the usual manner at the adjourned meeting,
Even
even
without-
without a quorum. But here there is no concept of a subsequent meeting, which
No,
the
my lord, my
legislature
lord.
has specifically put out here.
No, my lord, I have brought the meaning of subsequent also, my lord.
Ah.
It is again continuation of the earlier meeting.
Maybe,
meaning,
but
Black's law.
why the legislature have not used the adjourned meeting, which has been done in
My
1949?
lord, no, then my lord will kindly have a look at subsection 3 once again.
Yeah.
It is essentially an adjourned meeting. Please kindly see, my lord.
Mm.
If at any time in a meeting there is no quorum, presiding officer shall adjourn it to such a time or date as it thinks fit, and announce the same at once, and the business set down for the meeting shall be brought forth in the subsequent meeting, whether at such meeting there is quorum or not. My lord, when it uses the word subsequent, it refers to that adjourned meeting.
Maybe, but it is here in this rule, it says about the adjourned meeting.
Correct.
But here, you see, in many places, it says about the adjourned meeting.
Correct. Correct.
But
But my lord,
here it is only says about the subsequent meeting.
no, but lordship will also have to read the first two lines.
Hmm.
If at any time in a meeting there is no quorum,
Hmm.
the presiding authority shall adjourn it.
Hmm.
So what the authority will do, will adjourn the meeting.
Hmm.
It
And
is
there is
in
no
that
ti-
context, my
And
lord.
there is no time said, mentioned therein.
Yes.
Then how do you read this with 2? Wherein it says that if there is no quorum within this 1 hour,
No, my lord, there's no question of time, but it shall adjourn it to such time or date as it thinks fit.
so
Here it is in
no,
subsection.
then how do you read, therefore I'm saying 34:2 says that if there is no quorum within 1 hour from the time fixed for the meeting, then in that case, it will by operation of law adjourn to the next week. Date, time, everything.
Yes.
Then why, if it is in a meeting, the
No.
quorum was there,
No, my lord.
but the quorum has fallen, then it is only the question under 3 will
Exactly,
come.
Exactly.
Now here
Only
in the
difference
first,
is, my lord, only difference is in subsection 2, in my humble submission. At the beginning, within 1 hour, there is no quorum.
Hmm.
But subsection 3 visualizes situation when initially there is quorum, but subsequently there is no quorum.
yes. Then
So,
in
my
the-
lord, the end of the day, effect is both meeting are adjourned.
no,
And in the
there is a
adjourned meeting-
difference. First, the meeting can't start.
Yes.
So there is no meeting at all.
Even then, it has to transact the same agenda which was earlier there.
Understood. But just for example, let us take
No,
a situation,
Lordship is
what
correct.
you are saying.
Lordship is absolutely correct when it says to visualize a situation where meeting could not even commence.
No, just for example, tomorrow I hold the meeting. There is no person. I say that, okay, next day I hold, if we give the same meaning to 2 and 3, okay, tomorrow let us have the other meeting. I can. I fix the meeting tomorrow. No quorum, passed. The
No, my lord.
total member
End
is
of the
4,000.
day, end of the day, what will happen is, for lack of quorum, in both the situation, the meeting is deferred to another day. It is continuing, its continuity is there, my lord. Only in case of, my lord, the situation visualized by proviso to subsection 3, where, my lord, there is no continuity. Where in case of a requisition meeting, it will, my lord, if there is no quorum, my lord, then it will have to start afresh. In which case, the view which your lordship has taken will be attractive. That's my submission, humble submission for lordship's kind consideration.
Because
I
that,
think, my lord, this judgment, division bench judgment also says that, if your lordship will kindly permit me to complete that reading. The meeting was adjourned till 6/11/92. On 6/11/92, adjourned AGM was held and election was held. Adjourned meeting is the continuation of the meeting held earlier.
Hmm.
It is stated at page 41 of so and so that an adjournment if bona fide is only continuation of the meeting, and notice that was given for the first meeting holds good for and includes all other meeting following it up, following upon it, all other meeting. This is very important, my lord. It is only continuation of the meeting, and notice that was given for the first meeting holds good for and includes all other meeting following upon it. If, however, the meeting is adjourned sine die, a fresh notice must be given. It is also stated at page 66 of the said book that an adjourned meeting is deemed to be a continuation of the former meeting, and no new notice is necessary unless regulations so prescribed or adjournment has been made sine die. Learned Counsel has also drawn our attention to a decision of the Supreme Court in so and so, where reference is made to the above passage in law and practice of meeting. The adjourned meeting is in the eye of law, continuation of the former meeting. The meeting held on 6/11/92 was continuation of the meeting held on 27/10/92. The Administrative Council of the Society could hold the AGM on or before 31/10/92. The same stood adjourned for want of quorum, and the adjourned meeting took place after a few days. The Administrative Council of the Society was aided by requirement of Section 32(2) of the Act. That being so, the view taken by the registrar that there was dissolution of the Administrative Council under Section 32(4) of the Act is legally unsustainable. Consequently, the impugned order dated so and so is quashed. My lord can visualize it from another situation, my lord.
Mm.
My lord, lordship has seen the prescription in section 32, 39 and 41, where there is a requirement of holding AGM within a time frame. Now, supposing, my lord, a section of the shareholders who are having their vested interest, they somehow make it, possible that the meeting cannot continue and the meeting is adjourned. In which case, my lord, if the 30th September, passes off, in which case the body will get dissolved. So somebody can do mischief also. Therefore, I think it is another protection from that point of view also, my lord.
We can have it the other way around.
Yes.
Only the board of directors think that we should hold the meeting. We have 4,000 members, but we are only 50 or 60 out there. So let us do one thing, we'll call for a meeting. Others don't want. We call for a meeting, only 50 are present, so there is no quorum. Okay, next day we
No, my
again
lord.
appoint ourselves as the board of directors by holding another one, adjourn, no problem. Without a quorum, everything can be done. Then wouldn't that, the basic democratic, yes, section 41 may be, 44 may be bad. Because of not taking into account section 34. But can it be said that the entire democratic setup on the basis of which it is to be done has to be done away with?
No, my lord.
Because why
that
otherwise
is-
the
that is not my
concept of
submission.
quorum is there?
What I'm trying to say is, my lord, be it a situation visualized by subsection 2 or 3, both the situation, it is an adjournment. It is not a subsequent meeting.
No, when the
Subsequent,
word has been
Now,
mentioned as
Lordship will
subsequent,
kindly have a look at the meaning of the word. And before
no,
that,
no, can we say that the legislature
Hmm.
have used the word subsequent meeting just for the sake of it?
no,
superfluous.
Lordship will give a meaning to it.
So what is the
Lordship
subsequent
will
meeting?
give a meaning in the context. Not.
The meaning which I have already ascribed,
Hmm.
I have given is once there is a quorum and there is the quorum false, that is considered to be a subsequent meeting.
My lord will kindly have this Black's law, my lord, meaning of subsequent. And there is Central Act is also there, also I'll place my lord.
Yes.
In the second page, subsequent towards the bottom, following in time, coming or being later, then something else succeeding.
So it is a continuation.
it-
That is why, how can it be a continuation if there was no meeting at all at the first place?
No, that's why there was no quorum. My lord, only thing is, my lord, the legislature has visualized two situations. One, within 1 hour, there is no quorum. And the second situation is initially when the meeting starts, there is quorum, but midway there is no quorum. That's the only difference. The legislature has not done any further sub-classification. And in both the situations, the legislature intended that there is supposed to be an adjournment.
Now, if in a meeting is being called,
Hmm.
can you say it to be a meeting if there is no quorum?
That's why the meeting could not be held for lack of
No,
quorum
no,
because
no, there's a difference out there. Can you say that you are only calling for a meeting by way of a notice? Can you say that that particular, it is a meeting if there is no quorum? There's a difference
No,
on
my
that.
lord, it is something like this. A meeting is convened by way of a notice. People assemble at the venue. Now, law envisages a quorum. Now, they find that there is no quorum. Then what they can do? They'll have to adjourn the meeting. That is what is being stipulated in subsection 2. And subsection 3 stipulates a situation. Initially, there is a quorum, but subsequently, there is no quorum. In both the
No,
situations.
there's a difference out there. That is what I'm trying
No,
to
no,
say.
the diff- no,
Would you,
not-
can you say
Yes.
it to be a meeting of the General Assembly
It will still.
if there is no
No,
quorum.
my lord, in the proceeding books, it will be written that so and so meeting was called, meeting was convened. Then the chair found that there is no quorum. That will still be a proceeding of that meeting, my lord. And so it stands adjourned to so and so. In either situation, my lord, there will be proceedings of the meeting. Merely because the meeting could not be held, therefore it does not ceases to be a meeting. It ceases to be a meeting because it ceases to be not an effective meeting because there was no quorum.
No, no. Can you say, therefore I'm saying, you require 10% to be a General Assembly meeting. But if there is no 10% initially
Yeah.
at all,
Therefore,
can
therefore
that be a meeting?
Yes, that's a meeting where because lack of quorum, the meeting could not be held.
No, can it
Now,
be
therefore,
said to
the
be a
proce-
meeting of a General Assembly? No, it can't be. Because if we hold it to be a meeting of a General Assembly, then it violates 34(1). It would be only a meeting when there is a quorum and thereafter the meeting falls.
No, my lord.
Quorum.
34(1) envisages a quorum. If there is no quorum, then my lord, the meeting will be not validly constituted or the resolution taken in the meeting will not be valid. But there is no dispute regarding holding of the meeting.
No, you can't proceed with the meeting without the
Yes,
quorum.
precisely. Yes. So therefore, to say that there was no meeting will be not correct. my
No, therefore, no, that is what I'm saying. You can't say that to be a meeting of the General Assembly at all.
lord. Nevertheless, there will be proceeding saying that meeting was convened. The meeting could not be.
No, in this case, there has been some proceedings written. But then I have seen in many other cases, like with the case where I have decided, no quorum, stands adjourned. That's all. To the next week. In that case.
No, there's
No,
one more thing,
there
my lord.
cannot
Here
be.
in this case, the bylaw of the cooperative society is also there, my lord.
Understood, the bylaw cannot violate 34(1).
No, my lord, if your lordship will kindly have the central act, I have given a copy, please have it for a moment. There it is, section 31. Please come to page number 86, my lord.
Section 3.
30, no, my lord, subsection 3 of section 31.
Hmm.
Quorum at a general meeting. The bylaw may provide for quorum at a general meeting. In the absence of such provision in the bylaws, the quorum shall be 1/5 of the total number of members.
Hmm.
No business can be transacted without quorum. Even if the quorum drops during the course of meeting, the remaining business cannot be done and shall have to be put off. A meeting without quorum shall have to be adjourned to a specified date, time, place, and the business or remaining business, as the case may be, shall be transacted at the adjourned meeting, whether there is quorum or not. And no such business can be entertained at such adjourned meeting. No fresh, business can be entertained. The absence of quorum in the midst of a meeting may be brought to the notice of the president of the meeting by any member, if not noticed by him or himself. So, my lord, kindly see this subsection. A meeting without quorum shall have to be adjourned to a specified date, time, date, and place, and the business or the remaining business, as the case may be, shall be transacted at the adjourned meeting, where there is a quorum or not, and no fresh business can be entertained at such adjourned meeting. So, my lord, general scheme of.
So, Mr. Chaudhary, if you read this also, the remaining business,
No, my lord, there are
the
two things.
business or remaining business.
And the business or remaining.
So when can there be a remaining business? There has to be an initial quorum.
Yes, in case of my lord, our case, my lord, the remaining business will be covered by subsection 3. Initially, it started, some discussion took
No,
place.
in your case, there was no quorum at all, initially also.
Yes.
So then how
So
do you
therefore,
bring
it will
it?
stand adjourned. It will stand adjourned.
So it will adjourn for 7 days automatically.
Yes, no, my lord, as far as the, what to say, whether it is after 7 days or time to be fixed by the chairman, my lord, that will not detract. The effect is whether it is an adjourned meeting or a subsequent meeting. The use of the expression subsequent, in my humble submission, my lord, the meaning has to be given having regard to the
The continuation.
earlier
Subsequent use is because of a continuation.
continuation. My lord,
So
even-
that means something has happened and thereupon it is being
No,
continued.
my lord, even in 2 also, situation visualized by 2 also, the same meeting will continue.
Okay,
no other-
now, Mr. Chaudhary, I've heard you. Now,
Yes.
what is the relief?
My
you are
lord,
seeking for?
before my learned friend
lord.
starts, my lord, can I just point out one thing?
Yes.
Now, here in this case, my lord, against the order and appeal lies under section 111. Secondly, my lord, Lordship will kindly take note of few dates. 31/7/20 was the notice of AGM, fixing 11/9/2020. 11/9/2020, meeting was adjourned due to lack of quorum, and next date was 18/9/20. 18/9/20, my lord, meeting was held and board of directors elected. Then 21/9/2020, Assistant Register of Cooperative Societies approved the resolution. Thereafter, my lord, the writ petition was filed on 29/10/21. Well, that too after 13 months. There is no whisper in the writ petition. Why this delay? And my lord, against the order of the my lord ARCS, Assistant Register, an appeal lies. He never preferred any appeal. Or else, my lord, if we do not, hold the meeting, then my lord, the consequences also ensue. Anyway, my lord, that is not the, one and the only point. So therefore, my humble submission is, my lord, in this case, an appeal lies. And against the order of ARCS has given an approval.
Now, what has happened there? These are writ petitions of 2016. When did it?
The other three writ petitions have become infructuous, my lord.
Is still survive.
Huh?
Still survive.
For what?
For what, my lord, their board of directors, first, my lord, mismanagement. And they have misused the fund also of the bank.
Now, have you informed the
Yes,
register?
yes, I have informed all.
Now, what does the register do?
Nothing, my lord, the registry said, by way of affidavit in 23, they said there has to take action. After that, no.
Huh?
They said action has to be taken, but no action has.
In fact, my lord, this
So
gentleman. called-
2016-17 writ petitions are pertaining to mismanagement,
Mismanagement and misappropriation of the bank's fund.
bank's funds.
We have approached to the registry authority, depending.
And they have not done
They
anything.
have not. done
Have they
it.
filed affidavit out
They
there?
file said they need to have taken action.
We have filed affidavit in our affidavit page 100 lordship. We have written to the general manager, Cooperative Urban Bank Limited, and we have submitted the inquiry report and we have written them to take appropriate action in the year 2014 itself.
Then what remains?
No
Lordship,
action
they
has
dispose of
been
the whole matter.
No, have you made that cooperative bank, that bank, na?
Yes, yes, that very bank. I have approached all the authority. By work.
Well, he himself is a defaulter, my lord. He has
No, my
taken
lord,
loan.
no, my, he has not gone through the affidavit. Bank has given me no due clearance. Sir. What is the problem?
So these two writ petitions are separate.
Yes,
Yes, yes,
So I should concentrate only in
14.
2021.
yes.
এইকেইখন বাৰু- So here, what do you want?
I want my lord, lordship has to pass some order.
For what?
Lordship may-
What do you want?
That relief, my lord, I pray, my lord, or people see instant writ petition or the earlier one.
Earlier one.
Earlier one, my lord, I pray,
My lord, if I may
You
You
point
want,
out,
the-
my-
you want an SIT?
my lord. I will not only this, my lord, I
Then-
want to endorse a special investigation team comprising of finance and taxation department.
Huh?
Finance and taxation department.
Reserve Bank of India report to put-
A SIT from Finance and Taxation
No, my lord,
Department.
to find out, my lord. To
Then
find
why
out-
you are not going under this, why you are filing a writ petition, not going under filing a complaint?
Yes, I filed complaint.
No, criminal?
I filed a complaint to all the authority.
No, the criminal complaint?
Criminal complaint, my lord, first I have to serve,
No, you want the writ petition order.
yes, my lord.
Why?
Whether they have done or not, my
No,
lord.
if they are not investigating, there is a mismanagement, not a case of mismanagement, you are alleging
Misappropriation of-
misappropriation,
in
then
some
within the
cases,
case under this 406 and all whatnot,
Yes.
all these cases will be there.
my-
Why you are not doing
my lord,
unnecessarily
I
troubling
am
this
the
court?
same lordship, my
My
lord.
lord.
Lordship will direct, my lord.
No, let them, you go. I give you the liberty, you go there. These two writ petitions, why should, if there is no investigation properly done, you have the scope under
My
156
lord,
three.
they have crossed up to such a limit, my lord.
File a complaint before the police. You are saying about, you are asking for arresting.
My lord.
Then you want this court to exercise
my
the
lord.
power.
My
Anyway, that building is in shambles. You want this court to go and sit there.
No, my lord, I'm
Then-
not that.
My simple prayer is that, my lord, lordship to direct, my lord, the record they are running, my lord, that
Oh,
has
my
to be.
Goodness,
Yes.
racket.
And in some cases, lordship will see board of director even loan to his daughter.
Action against, one petition is that the register of cooperatives had to forthwith take action against the board of directors of the respondent bank and remove the board of directors. You want that?
My lord, which lordship?
That is,
And that board has might not already gone.
2016 2284. Are these people still the board of directors?
Some of them,
That board of directors is there or not?
no. that-
No, then this has become infraction.
Yes.
How can this court pass? Tell me.
17 will survive.
Say 16 goes.
17.
Now let us see 17. That is the SIT.
My lord.
Chalo, SIT.
My lord, petitioner is separate, otherwise the.
No, wait. SIT. SIT against whom?
SIT, my lord, not by the.
No,
criminal, my
why?
lord, by-
Against whom? You want an SIT. Against
SIT
whom?
By directing, my lord, any person, my lord. from
Again,
NS
no, understood. Against whom?
Against the, my lord, bank authorities, all, my.
Who is the bank? You are asking a initiation of a criminal proceedings against an office?
No.
Yes.
It is-
See who are the parties.
Chairman, board of directors,
And you are asking the office.
no, my lord.
Then you have to make those people whom you are alleging who have done all this mischief.
Respond number 7 is the cooperative bank.
Mr. Morvi, kindly appreciate. You want this court to say that these people have done something. Can this court say that the board of directors have done? It is an office. Can this court say that the office has done it? No.
Some person.
You are alleging misappropriation.
The bank, my-
No, you are alleging misappropriation. Are these people not required to be made parties?
Party, my lord, I made a chairman, board of directors.
The chairman keeps on changing. It is the post. Tomorrow, are you going to file contempt against the post? No, I'm asking.
No.
Then same. You are asking here that these very people are misappropriating. Who? The board of directors can't misappropriate. Can the office misappropriate? No. It is the person who can misappropriate. Then what to do?
Statement I have made, my lord. lordship.
Huh?
I made a categorical statement, my.
Then on the basis of making a categorical statement, your petition becomes bad for non-joinder of necessary party.
And it was the same board of director as is in item 16. Same board of director as is in 2016 writ petition at that relevant point of time.
Some of board of director, my lord, which is the impugn.
I think these two, nothing, but this is a substantial.
Yes,
2000.
Lordship, one thing, my lord,
Yes.
fairly submitting, my lord,
No,
lordship,
sir,
give me liberty.
Lordship's kind permission, can I take leave? Madam?
Yes.
Lordship,
The-
kindly
my
give
friend
me
would be there.
liberty to approach the appropriate authority, my,
For?
for initiation of the case against the person who has done wrong.
Very
That
well.
liberty be given to me, my lord, I'll take a legal report, either CID or PGM whatsoever.
Now tell me about that next case.
Next case, my lord, lordship has come,
I have seen the facts.
lordship has the.
I have seen the point of law. The
Yes,
point
ma'am.
of law is in your favor.
Yes,
I'm
ma'am.
making it very clear, whatever they may
Yes,
say.
yes.
I'm not satisfied with all those things. But the question here is what you have done. Let us see. Let's see the facts.
My lord,
Point of law is in your favor.
Lord.
Now, should the court exercise the point of law in your favor
yes.
in these facts?
In writ petition, my lord, I filed with a specific prayer,
You have asked for challenging the
AGM meeting.
51st annual general meeting.
as
You are
well-
challenging.
As well as the.
Dated 18/9/2020.
Fine.
Okay. Who are you?
I'm the shareholder. Of the
You are one of the shareholders.
shareholder, I have an my lord shareholder certificate.
Okay. Now, why have you challenged so late?
Huh?
Why have you challenged so late?
My lord, due to the pandemic, I have approached to the authority, my lord, due to the pandemic.
Oh, this was done during the pandemic,
Yes, ma'am.
18/9/2020.
Yes, I have approached to the Deputy Commissioner, page 29 is in my.
What is the deputy commissioner going to do?
No, my lord, without permission in the pandemic, my lord, they did intentionally, my lord, in a Hari Sabha. Small place to show the meeting has taken place.
Okay.
From the record, my lord, on the earlier occasion, it was seen from the record, there somebody said it is in Uzan Bazaar.
Hmm.
In fact, my lord, in reality, from the record, my lord, lordship will see, someone says it is, meeting was held in Uzan Bazaar.
Hmm.
Some, even from the record of the, it is, my lord, that no observer put signature. He is
Hmm.
not, he is not there.
Affidavit in opposition of response. You have shown me some documents where notice on that day, Janoni, then this,
Yes.
page 28, na?
Page
Total
28 is the meeting, my lord. The first
number of shareholders present is 22. Very well.
Then, my lord,
Then
page,
they hold another one
no, my
having
lord,
101.
chronologically, I am going, my lord. Page 24, I have approached to the deputy commissioner,
Hmm?
that, my lord, without,
Page
page 29, without due
29.
permission,
Page 29.
9.
Yes.
They have violated, my lord, SOP of pandemic. Then 30 also I have approached to the superintendent of police commissioner.
Then
Then, my lord, the impugn order, another one, page 31. There, my lord, subsequent meeting, they said 101 member out of 4,000.
so you knew about it.
Yeah.
You knew about the meeting.
I knew. That's why I funded.
Then why you knew about the meeting on 18/9? Then why did you
My lord,
approach
copy-
this court so late?
Late, my lord, we have to obtain under RTI.
You obtained under RTI.
RTI.
Where?
My lord, that document is right now, application is not with me, my lord. It was
Huh?
supplied under RTI. Oh, it is
Where?
there, my lord.
Have
No,
you
my
made a statement? You have filed an affidavit also, reply. Have you mentioned? They must have said something about the delay.
no, my lord, no, they have not taken that.
They have not taken that point
No. Activity there.
by submitting here. Here, paragraph 6 of the affidavit, paragraph 6 of your reply. Before the deputy commissioner and so and so and so and so and so remained silent over the matter and which did not feel it necessary in deviating the SOP further perusal of the annexure 1 has been protected as per the record.
As per the observer report, it was held as forum of
Right.
controversy.
The authority of Hari Sabha.
It was. There are.
Then when-
Of the order. in the respective-
Okay, and then
Then, my lord, from the affidavit, my lord, they state, my lord, page 45 of the respondent 1567. They state page 45 annexing a document
who is the respond number 1?
is the cooperative department.
Oh,
No.
yes. What do they say?
What they have annexed a document.
By
my
the
lord.
respond number 4? No.
No, respond number 4 is the police.
Okay, what do they say?
In page 45 be seen, my lord.
Hmm.
Mrinal Saikya, inspector of hereby appointed as the observer to attend the AGM meeting, Cooperative Bank, scheduled to be held on 11/9/19 at the 10:11 a.m. Auditorium Hall of Sanatan Dharma Sabha, SGS Road, so and so. He is directed to guideline the government regarding the COVID-19 pandemic followed by the bank during AGM and to submit the observation report. A total 20 shareholders are allowed to meeting and physically and others may obtain the meeting through online. But this online has never been done. That order has not been followed, even though, my lord, the Register of Cooperative Society, my lord, has approved the impugn minutes of the meeting. Thank you.
So they don't say anything.
No. Just for a mere namesake, my lord, this can still.
They have just filed it for a names. And what do they say?
They
They
say,
have
my
filed
lord, they,
affidavit.
they have filed their affidavit. Who affidavit?
What do they say in their 9, 10 and 11?
Yes.
What
9,
do they
10,
say?
9, 10, 11 to start matter है. 9, 10, 11 affidavit. Or 9, 10, 11. 9, 10, 11, they are justifying their meeting. Man. They are hammering on the law point. They are justifying, my lord, their Bible.
Okay. So this is a point of law.
Man.
So we need not remand you back
Yes.
to here. Okay.
It has to go, my lord.
Okay. These two goes,
So, my lord, lordship will give
these two, this order will be passed
giving liberty, my lord, to approach the appropriate authority
for what?
for taking, my lord, action against some.
Those boards are not there. This board is no longer there. And you have,
Some of member are there.
maybe, but that is the same will be different now.
Yes,
So in view of the new board of directors being formed, this has gone. But if you want to take any action, you may take the normal course of,
yes,
do you
yes, that.
so this is there. These are disposed in this.
Ah.
And this
My lord, has to be
repetition is allowed. I'll pass order to the
lordship.
and allowed. Now the thing is, once it is allowed, the consequences is you will appoint an
One man,
officer,
add one man.
One minute, one
one man officer to hold it within 90 days.
minute.
41-6.
Lordship may observe.
You get the order.
Can I get the original-
Monday, huh? Monday you'll get.
Original record.
What original record? I don't have the record.
Yes,
Leave the-
record is with
Record is
honor
there, my
before.
lord, on the last occasion, it was found and seen, my lord. The
Huh?
very observer, he did not even put signature. Someone says, and there is a temperament of, my lord, number of shareholders.
Sure.
That
And
has been
according-
found by another court, my, but I have not gone through the record. But at the
These
time,
records have been called for what purpose?
for perusal of.
No, there is no quarrel with, why should we go into the records?
Yes,
It is an admitted fact.
Yes, no,
That-
law is violated.
On 18/9/2020, there was only 101 shareholders. And it is also an admitted fact, so and so.
20.
But one thing I will observe, that as they have been under an impression that it has been done in accordance with law, the disqualification under section 41 shall not be enforced upon. That I look. Because that is, they were under a bona fide belief and they had held the meeting. So this court cannot obviously say, because otherwise the moment I set aside 39 hits, 40 will hit again.
Lordship, my lord, what is my humble submission is that, my lord, lordship, if given some protection, they have no protection for that. But lordship will pass an appropriate order, my lord. Appointing, my lord, one man.
I am not going to appoint one man.
No, my
I'll
lord,
direct the
direction.
register to appoint.
Yes.
I'm not business.
Direction
In fact,
has-
yesterday I was submitting one thing, not submit. There was a argument which was going on regarding age of retirement.
Yes,
So I was saying that this court has no business. I can't fix the age of retirement.
Yeah.
And yesterday the Supreme Court has also.
yes,
passed an
like law, I
order
have
to this.
seen that, but it cannot be.
And there is another judgment which is very relevant when they were pointing out other thing. When the act is very clear.
Yeah.
All other acts will have no bearing on.
No.
Here the act is very clear as regards meeting and subsequent meeting.
Keep your leisure.
We get it on Monday, huh?
My lord, only, my lord, liberty be given other to take.
What?
Liberty to take in initiation of that.
Liberty means I will say that nothing survives in view of that meeting. However, the petitioner may avail such remedies as permissible under.
My lord.
Someone say, a records written.
Keep your.
তিনটা ফুল।
And number two,
Yes. Oh, Mr. Sen. That means the sum of the petitioner have not been received a single penny. On the other hand, it is the stand of that they have received some amount. Produce the records. What the records? Direct the additional year होता है to produce the LIC on the next page. This is as regards you have not received the money. So it is goes from back. Some Urdu type. I was looking on the back side. You are concerned with 2 bighas. How much land?
2 bigger 4 cut.
2 bighas, 4 kata, 15 land. That's all. You have received the money? You are appearing for?
I am for the respondent number 2, madam.
Who is respondent number 2?
Railway.
Railways, you have paid the money.
Yeah.
Have you paid the money to them?
Yes, sir.
You have paid how much? 4 crores 31 lakhs.
4 crore.
and according to the list, that the bank list, the name to the petitioner is not figured there.
One is not figuring. No, madam, you just tell me whether you have paid 4 crores 31 lakh 35,507. You have instructions?
Yes, madam.
How much money you have paid?
3 crore.
3 crores 96 lakhs 20,806.
Why you have reduced it?
Page number.
Madam, why have you reduced the amount?
But in their affidavit, they have stated that four crores odd millard they have millard paid, millard sanction, out of which millard 3 crores has been disbursed.
Have been paid by railways.
To the, yes. Railway by their affidavit filed by the railway millard. Annexure A, page 7. Page- Annexure A, millard. Page 75. 4 crores 55
55 lakh 66,
66,900.
4 crore 55 lakh 66,961.
You have paid.
Yes.
Show me that. And who is the person who is not paying, madam? Who is not paying?
The list of beneficiaries which is referred to annexure J.
Hmm.
There too, my lord, their names don't.
No, this
figure.
is an estimate.
Yes, my
How much you have paid?
Millard, out of
Reference
your
to
law,
their land,
my
cost
lord,
of land
that's,
acquisition
I
under
think second or third
so
page.
sanction is given. And pay order issued in favor of the
Fee or
deputy
what?
commissioner land acquisition of an amount of rupees a year. So this 13/7/2023, the amount of rupees 4 crores 55 lakh 66,961 was paid.
Yes, my lord, according to the bank.
No, as per them.
They paid, yes, my lord. They
Then if it is paid, why the petitioners have not been paid?
paid. The list of beneficiaries which they refer to, that's annexure J, my lord, of the
Ah.
brief, of the record.
Ah.
Then there too, my lord, their names don't figure and the lands, the dark numbers, they don't figure there.
So you have not acquired the land.
That's what it looks like. my lord.
No, it doesn't looks like. Why,
But
first
then
of all,
again, there is that notification which calls for the social impact study. but Where
It's all
dark
happening.
numbers 612 and 614 figure.
Annexure 1 series, millard,
Mr. Sen,
Yes.
do you have a right over these lands?
Yes, millard.
How do you say so?
My lord, notices, my lord, need to issued by the authorities against us. Lord.
Where? No, notice, merely issuing notice would not do. Now show me that you have a right over the land. Where is the land acquisition, page 52? You are there? That is the problem with so many petitioners filing. One petitioner is easier. Show me page 52. Are your names here?
My lord, at page 47. your-
Page 52, Mr. Sen. Come to page 52. This type of writ petition should be dismissed because of that. Are these the petitioners?
Yes, my lord.
Huh?
Kishore Kumar Das, Janto Kumar Das, Sushil Kumar Das, Shambhu Kumar Das, all these are, my lord, the petitioners. my lord. Kishore Kumar Das, Janto Kumar Das, Sushil Kumar Das.
Oh,
Shambhu Kumar Das,
oh. Mr. Sen,
my lord.
I have asked you to pay the deficit court fee. Have you paid?
Yes, my lord.
How much?
60 rupees, sir.
Why? How many petitioners are there? How many petitioners are there?
24, my lord.
24. Okay, choose one of it. I'll pass the order only in his favor. Rest the petition stands dismissed for non-payment of court fee. Yes, which one? Which one do you want?
My lord, I'll pay that.
Which one?
I'll pay the court fee. I will.
No, now this court fee will be there with a cost upon you of 5,000 rupees. This court had earlier directed you to pay. The problem arises because of filing of petitions like this.
But I have paid 40 million only. 50
This-
million. That is my.
No, isn't it this court specific thing?
Yes.
Mr. BK Sen, see, here it says, Mr. Learned Counsel on behalf submits that some of the petitioners have not received. On the other hand, it is the strength of so and so. Animan is so and so. Then here it says, I must have passed some order. We have paid only 60 rupees. Can't happen like. 21/8/2023. One. Mr. Sen, kindly show me where are the ownership documents of these petitioners? That you are the owner of these lands?
That we have,
No, how would this court decide that you are entitled to the payment?
because, my lord, they have served notice upon us, my lord.
No, issuance of notice upon you, would it mean that you are the owner? No, I'm asking you.
That, my lord, we have satisfied them, my lord, that we are the owner. Thereafter, they have.
You are to satisfy this court. Are you or not? Then,
That's true, my lord, because they have served notice on us, my lord.
okay,
Oh,
we
yes,
dismiss the
but-
petition on that ground itself.
I'll produce the document.
No, I'll dismiss the petition on this ground that this court is not satisfied with the documents that you are the owner of this land and as such
All these-
appropriate orders
All
can't be
these
passed.
petitioners are owners, my lord.
I can't say, you have not satisfied.
My lord, notices have.
The
been-
instant repetition was filed.
My lord, your lordship can.
No,
My lord,
no, Mr. Sen.
My lord, I may be allowed to produce the documents, my lord. Some
Which
of them,
documents?
My lord, the land documents. I am having all land documents.
Then why you have not enclosed?
I have not enclosed, my lord, because the prima facie, my lord, it is, my lord, proved that we have given to them and they have satisfied, my lord, thereafter they have acquired my land.
Show me that. That there is a prima facie opinion expressed by them that they are satisfied that their land belongs to you.
My lord, least is their names are there. my
Show
lord.
me that. Show me that. I want only that.
Yes, my lord.
Show me that.
Yes, my lord, my lord.
Merely issuance of notice would not be that you are the owner.
Page 52, your lordship.
If there is any document being issued that you are entitled to compensation,
My lord.
then it is okay. Show me that.
My lord, this is the description of land, my lord, and the name of the owner.
Where?
My lord, that page 52, as your lord,
50?
52.
Page 52 is different.
Page 52 is Form C notice.
Where
my
the
lord.
land described has
Yes.
been requisitioned under section Iman and you being the owner, tenant, person in Iman are directed to surrender or deliver.
Yes,
And are these petitioners, the names are there?
yes, my lord.
Which are the petitioners?
Kishore Kumar Das, my lord, it is figured, my lord.
Petitioner number?
I'm showing you. Two, my lord. Petitioner number 2, Kishore Kumar Das. Then Joyanto Kumar Das. All are there, my lord. These are.
No. You have to be careful.
My lord. Then Kishore Kumar Das.
The instant writ petition has been filed by the petitioner.
My lord, Kishore Kumar Das is there, my lord. And others also there.
Being aggrieved
Shambhu Kumar Das.
by the non-payment of compensation to the petitioners. As to which the petitioners are entitled to. Under the right to, entitled to, under the provisions of law. Full stop. It appears from the perusal of it appears from a perusal of the writ petition that there are 4 writ petitioners, 24 writ petitioners. However, the court fee of only 1 writ petitioner has been paid. Full stop. The claim made in the instant writ petition is specific entitlement of the petitioners to the respective amounts under the land acquisition proceedings. And as such, each of the writ petitioners have a separate cause of action. Under such circumstances, each of the writ petitioners were required to pay the court fee. Miss,
Yes, Hazari.
appearing on behalf of
Respondent number 2.
the respondent number 2 submits that as per the estimates so given by the land acquisition by the deputy commissioner, was I? Mr. Sen, kindly take your seat. Deputy commissioner, I am passing an order in your favor. Take your seat.
Deputy Commissioner Hojai.
Ho jaye. The learned counsel appearing on behalf of the railways submits that in pursuance to the estimate given by the deputy commissioner and collector Hojai of an amount of rupees 4 crores 55 lakhs 66,961 for acquisition of the land measuring 2 bighas, 4 kathas, 15.79 lesas of village Hojai town 1 number and Hojai town number 2 Isam under Hojai Moza. The said amount have been duly paid in to the deputy commissioner land acquisition branch by a pay order as far back as on April 8, 2017. That's the document. See here. Go on, look at it. Madam, see the last paragraph of that order. Last paragraph. Last paragraph, last paragraph.
Yes, 4/8/2000.
17. Most surprisingly, the revenue officials and most surprisingly, from the perusal of the records today, nothing could be seen that the petitioners have been paid any compensation by the revenue authorities. The records which was placed by Ms. S. Sharma,
Yes, Hazarika.
Madam, please the S. Sharma, Ms. S. Sharma, the junior government advocate is returned as there is no clarity as regards payment made to the petitioners. Although there was a specific submission made before this court on 9/8/2023 that the petitioners have received some amounts. Under such circumstances, this court directs the Deputy Commissioner Hojai to file an affidavit on 7th of September 2023. By 7th of September 2023, as to how much amount has been disbursed to the petitioner pursuant to the receipt of the said amount by the by the Office of the Deputy Commissioner, Land Acquisition Branch, Hosai, as far back as in the year 2017. Full stop. This court list the matter on 8th of September 2023. Full stop. It is observed that if the affidavit is not filed stating the reasons as to why no payment of money, no payment of compensation has been paid to the petitioners, this court shall have no other option to pass appropriate orders against the office of against the Deputy Commissioner, as well as the other officials of the branch, Land Acquisition Branch of the Office of the Deputy Commissioner. Hosai. The record so produced is returned to Ms. S. Sharma. Ms. S. Sharma shall duly communicate the Deputy Commissioner Hosai. Now you have a Deputy Commissioner?
ADC in charge. ADC in charge.
ADC in charge Hosai. Then it has to be filed by the ADC in charge.
ADC in charge.
আগতে Deputy Commissioner Hosai নিদিব, ADC in charge Hosai. ADC in charge Hosai. এটো দিব। Are you go? Shall return to hear it and shall intimate the ADC in charge Hosai about the orders so passed herein. Full stop. Mr. B.K. Sen, the learned counsel, appearing on behalf of the petitioner, submits that by the end of the day today, the court fee, the remaining court fee in respect of the other petitioners shall be paid. Deposited before the
Okay.
Ms. S. Sharma by the court master of this court during the course of the day. Right.
Item number 3.
I am appearing for respondent number 4.
Yes.
The son of the petitioner murder was a student of IIT Guwahati. Whose dead body was found in a mysterious Whose dead body was
You are paying for?
I am appearing for respondent number 4. The
Yes, tell me.
hospital authority. I have already filed affidavit. Today morning I filed affidavit in opposition. Kitana wants to correct his date of birth.
He's working in your place.
No, Lord. He was born in our hospital.
Okay. And you have given a certificate
Yes, Lord.
that he was born on this date.
Yes, Lord. As per section 8 of Barton.
Who is appearing for the union? I think the union has to be appearing. 1 and 2. No union. No union council? And petitioner is also not represented. Who is the lawyer?
Ace Borua.
Hmm?
Ace Borua.
PP Pupon. You have filed affidavit?
Yes, Lordship. We have issued a certificate that he was born in our hospital. And XRG, of the report. Page 20.
Your affidavit is not on record.
Yes, Lord, today I have had.
Okay. None appears on behalf of the petitioner. Mr.
D. Sutia, for the respondent number 4.
Rishutia,
Respondent number 4.
appearing on behalf of the respondent number 4, submits that an affidavit has been filed. Lists the matter after 4 weeks wherein the said affidavit be brought on record.
Obliged.
Please, please can bring on record the same.
Obliged. Item number 4.
Yes,
My pleasure. My letter. Son of the petitioner was a student of IIT Guwahati. Whose dead body was found in a mysterious condition in the campus of the IIT. There,
Hmm?
in the campus of the IIT. Thereafter, a police case was registered. But being agreed, the wife of the petitioner filed a letter addressing the Chief Justice of Guwahati High Court. And thereafter, a suo motu PIL was raised without the knowledge of the petitioner.
suicide case.
Well, according to the police report, according to the police minute, suicide case. And
Then?
they filed FR also, my lord. Therefore, I have filed protest petition. And the learned CTM has passed an order on 21/2017.
Where is it?
My lord, Annexure 2 page 16. Annexure 2 page 16.
Of?
My writ
When did you file the writ petition?
petition I filed, my lord. This week,
Annexure 2 page.
January 2020.
Yes. Yes, then what happened?
Thereafter, your lordship kindly see page 26.
Hmm?
Page 26, annexure 4.
What is the order date?
Which one?
21/2017.
Yes.
Then page?
Then page 26, annexure 4.
Hmm.
This is issued by the Secretary to the Government of Assam Home and Political Department. Ministry of Personnel, Public Affairs, Pension Department, Personnel and Training, Government of India has been requested to taking necessary action for handing over the case to CBI.
Hmm. Then?
After that, your lordship kindly say annexure 5.
Yes.
Paragraph 2 is important. The matter has been considered in this department in consultation with the CBI, and it has been observed that the case does not have any interstate ramification and does not have any complexity which cannot be investigated by the state police agency. Also, the Honorable High Court hearing, the PIL in this matter has expressed satisfaction about the investigation done earlier by the state agency.
Then?
That order is at page 14.
Then what is this another repetition?
Thereafter, my lord, this PIL order was passed, my lord, without my knowledge.
Which one?
PIL order.
Ah.
Thereafter, my lord, I have filed a review petition, my lord. Your lord will get annexure 7 page 34.
Yes.
And here, my lord,
Yes. What is the order?
order relevant question is at page 37.
Hmm.
May I read, my lord, the relevant
30?
37, line 3 from the top.
Yes.
Therefore, to the extent we clarify that the order dated 31/10/2016 passed in PIL number so and so, which had also resulted in disposal of writ petition so and so, through the order dated 15/6/2018, would only limit itself to the prima facie consideration to that effect. However, insofar as the grievance as being put forth by the review petitioner, since the learned magistrate through the order dated 21/2017 in DR case number so and so has directed further investigation, the said order shall remain to the benefit of the review petition, which would be taken to its logical conclusion, and the order dated 31/10/2016 passed in PIL number 20 shall not be treated as an impediment for the review petitioner to exercise their right in accordance with law. Thereafter, my lord, we have submitted the copy of this order, but the matter was kept pending.
Then?
Then, my lord, I have again filed the writ petition, this present petition matter.
What is the
On the
affidavit filed by
count,
respondent number 7? Who is respondent number 7?
Respondent number 7.
IIT.
Right.
They don't say anything. Then what is the affidavit filed by respondent number 8? Who is it? Superintendent of Police. And what is this one, this order? This is submitted on 14th of February 2023. So what happened out here? In your case, what has happened? What have you done? Huh? Yeah, that affidavit is premature. I mean, it is, thereupon you have submitted this thing. On 14/2/2023, the superintendent of police Assam had stated that FR has been brought. That FR is being brought out. What happened thereafter? What happened to the FR thereafter?
My lord, I have not received anything from the court, my lord. If they have submitted, was supposed to get a notice, my lord, that I have any obligation. Till that I have not received.
Have you challenged this FR?
No, my lord, this is not filed earlier. Now they are saying they have filed the FR. I don't have any copy of it.
And have you filed the FR before the court? 29? No, before the court. When did you submit?
My lord, in their affidavit, they have said that on 29/4/2019. They have filed. They have-
This is the FR, no?
Yes.
Which have also been forwarded
Second FR.
the second FR.
Whether the second FR has been influenced by the PIL's order or not.
Hmm?
Whether this second FR, my lord, has been influenced by the PIL order or not.
Have you seen the FR?
No, my lord, I don't have any copy.
Stay here. You have the FR copy? Give it to him. Okay. We'll take it up at 2. Give you and get the information. When did you file the FR? Submit before the court. Because this is 2019, we are in 2020. And Mr. Kakoti, you are appearing for?
I'm for SMART 7, but I think. In fact, we have nothing to say in this matter. Whatever the parties.
We'll take it up at 2. We get there.
Double I.
Item 5.
Yes. What are you challenging?
We are not able to appear in this case, court. We are not able to appear in this case, court.
Why?
In this second on the 19/4/2021 order was not posted. Directed us to inform the registrar. And accordingly, we have informed. Our letter is that to take. Take it. We have sent one copy to the petitioner also to pass the code.
Have you sent this notice?
The notice to the petitioner.
Huh?
Yes, sir. To the instructor.
This case, we file a wakalat number, but we.
You are appearing for?
I'm appearing for this one number 3 bank, Manoj. Because we have not been served with a copy of the petition. And there is a stay order operating against an order of the DRT. Says the petitioner has lost.
You have given the notice?
What's it?
You have given the notice?
Yes, sir.
None appears on behalf of the petitioner on call. In spite of issuance of a notice by the earlier set of councils on 24/2023. Mr. A. Ganguly appearing on behalf of
Number 3.
the respondent number 3.
Yes.
Submits that they have not been able to proceed with the debt recovery proceedings on account of they have not been able to proceed with the certificate issued in favor of the respondent number 3 bank on account of a status quo order being passed by this court on 12/2/2020. This court have duly taken note of the order dated 12/2/2020, which was extended by an order dated 12/5/2020 till the next date of listing. Subsequent thereto, on 24/11/2020, it was mentioned that the interim order shall continue. So taking into account that the petitioner is not represented, this court is not inclined to extend the interim order passed by this court earlier. The respondent bank, the respondents, including the respondent bank, shall be at liberty to take such course of action as permissible under the law. This is the matter after the summer, after the puja recess was on 29/11/2023. So it is made clear if the petitioner is not represented, then the writ petition shall be dismissed for non-prosecution. 6.
Subsidy
Yes.
matter.
What is this?
Subsidy matter, Lordship, it was CCIS subsidy. So matter was in fact, Lordship, ready for placing before the SLC.
Hmm.
Then there were certain CCIS matters which are pending. So last SLC, it seems it's happened on 27. But this matter was not placed before the SLC because the matter was sub judice, some kind of mistake they have committed.
Who? SLC.
The department. So Lordship may direct it to be placed before the SLC, the next SLC, whenever it happens. Audit again, Lordship, they'll have to.
What is this for? Representation dated 27/2019.
27.
So they have submitted a representation.
Yes. But they have submitted the representation. Actually, what has happened when they first claim, like filed a claim, certain documents were not there. Because of that, it was informally placed before the SLC at that point of time. Then they have submitted all the documents. Then accordingly, we have filed an affidavit also that the matter is complete now. So we'll place before the SLC whenever the SLC happens.
Where is that?
That
Affidavit filed by?
affidavit filed by the Department of Lordship, it was filed on 8/2/2023.
8/2/2023.
Yes.
6/2. Affidavit filed by the respondent number 1 and 2.
And 3 and 4 also. This should be another one. That's a union government.
Okay. 8. What is your stance?
So page 105, if your Lordship comes to
105?
this, I mean, that serial
No, no.
pagination.
Can be 105.
Serial
Your
pagination.
petition starts from 135. Your affidavit.
Okay, they have mistaken then. Like, anyways, Lordship may come to paragraph 9 then.
Para?
Para 9.
Claims of a petitioner could not be placed before the SLC held on the lack of What is this DPIIT?
That's the central government ledger, Department of Industries and Industries and Promotion. One second, okay, I'll just do it. Department of Industrial Promotion. That is a central government authority which Lordship, Department of Promotion of Industry and Internal Trade.
Hmm.
So they are the basically sponsors of this schemes and policies. So the permission was sought for, permission was got, they have received the permission.
Now you have got the permission from the
Permission.
DPIIT.
DPIB, they have got the permission. Lordship, what has happened is that on what I got the instruction is that on 27th of August, 27th of July, so 27th of July, some SLC happened. But this matter, they did not place it because they thought there is a sub judice matter. So there was some mistake committed by them. The department.
When are you holding the next SLC?
Next Lordship, I'm not sure about this. I'll have to take instruction on this. So Lordship may direct like whenever the next possible, I mean, at the earliest, they can.
The instant writ petition has been filed. Claiming, seeking a mandamus, thereby directing the respondents for making payment of 30% subsidy under the Central Capital Investment Subsidy Scheme
Scheme.
2007, as well as also for consideration of a representation submitted on 27/2/2019. It reveals from the records that the claim of the petitioner for the capital Central Capital Investment Subsidy Scheme could not be placed before the SLC state level committee meeting before 31/12/2019 due to lack of required documents and clarifications. However, after the receipt of the required clarifications and necessary documents, the claim of the petitioner was made ready to be placed before the state level committee. Thereupon, there was a requirement to obtain the approval from the what is the D?
DIPP.
Yes, what is that? Department of
Department of Industrial Promotion and Internal.
No, Department of Promotion.
Department of Industrial Promotion.
How can it be the industry?
Department of Industrial Promotion,
What is this P?
DIPP, Department of Industrial Policy and Promotion.
Before the, however, there was a requirement of obtaining the approval from the DPIIT.
Yes, Department of Industrial
Mr.
Policy.
A. Kolita, appearing on behalf of the Industries Department of the Government of Assam, submits that the said approval have also been obtained from the DPIIT. But on account of the pendency of the instant writ petition, the same was not placed in the last SLC, a state level meeting, committee meeting, held in the month of July 2023. So, taking into account that the papers pertaining to the claim pertaining to the central subsidies into a central interest subsidy
Central Capital Investment Subsidy.
subsidy is ready with the respondent authorities, and it is on account of the pendency of the instant writ petition. The claim of the petitioner could not be placed. This court disposes of the instant writ petition with a direction to the respondent authorities, more particularly the Industries Department of the General Manager,
General manager.
The general manager of
No, the lordship made direct SLC. SLC will do.
they will consider.
Correct.
That it has to be placed by the general manager.
It will place by them.
By the general manager, district industry
Industrial
center
and Commerce Center.
to place the
Concerned district industries and commerce center.
concerned district industries and commerce center to place the papers pertaining to the petitioner before the next available state level committee meeting. The state level committee meeting thereupon shall consider the application, consider the claim of the petitioner on the basis of the, in terms with the policy conditions, and thereupon pass appropriate recommendations so that the petitioner receives the central to subsidy to the subsidy
Central capital
If-
investment. Center.
permissible under law.
Lordship, one line may be required like that. Necessary approvals from the DIPP may be required for SLC. Necessary approval from the DIPP. That may be-
There's already there.
No, that already happened, Lordship, that SLC. For another SLC, they may require it.
It is further observed that the respondent authority industry, who requires that?
Industries department. will look.
The respondent industries department shall also take do the needful. Plus, shall also do the needful for the purpose of holding the state level committee meeting at the earliest, including the permission, if so necessary, from the DPIIT.
Applies, Lord.
Petition this. The above observations and direction petitions.
Seven.
But in this case, I need 2 weeks time, Lord, because my position is
Matter pertains to
not kind of landlord.
what?
Pass out for the time.
Why?
Election,
Number 20.
election,
Will not be directed to complete the proceedings initiated by the so and so and responded by so and so by letter for allotment of land for housing accommodation. Mr. Gustami, you were earlier also granted time in 2022.
Sorry, Lord.
We are in 2023. Every time you are asking for time, what is it?
Okay, last one.
That's for what?
Getting it.
List the matter on 18th of September. On which date? Mr. N. Gusami, the learned counsel, appearing on behalf of the respondents, shall obtain the necessary instructions as to why the petitioner should not be granted, as to why the petitioner, why the proceedings initiated by the Deputy Commissioner Kamrup Metro by the letter number KRS 769/2016 dated 15/9/2017 for allotment of land for housing accommodation of the petitioners should not be issued, should not be proceeded, should not be brought to a logical conclusion. It is further observed that the respondent authorities have on the earlier occasions have been seeking time in the matter since 2022. No further accommodation shall be permitted. 8. Yes, madam.
My lord, I am here for respondent number 9, 10, and 11.
Yes.
My lord, the petitioner's hearing has challenged the withdrawal of my suspension, my lord, by letter in the year 2019, my lord, at annexure A, my lord. The PDS license,
You were suspended from where?
my lord, no, PDS license of the PDS license of the PDS license of petitioner, Pisola Gao Panchayat Samobai Committee was suspended. And thereafter, the suspension was withdrawn. They have challenged that through this writ petition. In the meantime, my lord, new committee has also come in. And in the new committee, though respondent number 9 and 10 remains the same, 11, the secretary has changed. So, my lord, I don't think there is something in this petition.
They are challenging the
They are challenging two aspects, my lord. One is
setting aside and quashing the impugn order dated demand issued by the deputy commissioner, withdrawing the suspension of the license issued in the name of respondent number 3,
my lord,
respondent number 9,
9,
and for quashing the license of the respondent number 9,
my lord.
and should not be directed to and so to the respondent committee as well as the cancellation of registration of so and so.
The PDS license was cancelled. Thereafter inquiry and after report, it was again withdrawn and we are presently running. In the meantime, new committee has formed in and during the pendency on my lord 28/6/2022, new committee has come in wherein the president remains the same. The new committee, new secretary has also come in, my lord. So this writ petition, my lord, I'm not quite sure that whether it remains.
But his case is against you.
Against the withdrawal of the PDS license, my lord.
Huh?
Initially it was withdrawn and again it was reinstated, so he is against that, my lord.
Look,
The petitioner.
But
The
his cause of action survives.
cause of action is same, but if that remains, my lord, then
Okay.
11 has
None
to be.
appears on behalf of the petitioner on call. Full stop. This court fixes the matter again on 29/2023. It is made clear if the petitioner is not represented on the next day, the instant writ petition shall be dismissed for non-prosecution.
Must apply to.
9.
May I please, Lord?
Hmm.
My lord, the petitioner may not have paid for a petition, but for payment of the amount, my lord, the case of her husband, my was killed in a post, my lord. He was driving a requisition vehicle for operation of the police force. And during the time of duty, my lord, he was killed by the military. My lord, kindly
Then?
say case 16, my lord.
What would they say in the affidavit?
The affidavit, my lord, not filed.
Not filed.
Page 16, my. Page 16, this is my lord, FR, my lord, and then 17 relevant, my. During investigation, it's dash form.
What is the name of your petitioner?
Petitioner, my lord, Maina Basumata, the wife of the deceased man.
The fund is there.
Okay.
Now, have they filed any affidavit? No.
No, my.
Yes, what is your stand?
My lord, the person died in the another state.
Huh?
The person killed by extremists died in some other state. In Shillong,
In Meghalaya, my.
Meghalaya.
Then how can you get it?
Even
Because it is in the state.
In the
If
state.
I read it 1511 where?
16, my lord, but I have.
Where is that, where is that particular one?
And at page 31, my lord,
Page 31.
page 31, this is the order.
No,
my
no,
lord.
no, 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 yeah, page 28. The revised rates shall be applicable in respect of incidents which may occur in the state.
This is-
Tell,
My lord, in Meghalaya also, outside the state, my lord, state government, my lord, have paid.
go to stay Meghalaya.
Meghalaya.
Go to Meghalaya. The accident happened at Meghalaya.
Page 31, ma'am. I have annexed.
Page 51. Yes,
This is the order, my lord. Yeah, people of Assam, my lord, they died in state of Meghalaya, my lord.
they died where?
They died in Meghalaya.
Some court passes something order. This has Mr. Bhattacharjee was not there to oppose. Does it mean that you will be getting the same thing? Sir, this is a policy. A policy is based upon the state saying. Can this court say, no, you change the policy?
My lord, then I have filed additional affidavit also, my lord. After 2014, my lord, also they have paid.
Hmm.
I have brought this on.
Let
record,
them
my
pay
lord.
whatever may be. But now they are not going to pay. When did the incident happen?
Incident, my lord, happened on, my lord. 2016.
So then, what do you mean? The instant with petition has been filed
My
by the
lord,
petitioner.
another notification, central notification is there, my lord. I am entitled for that notification.
Which one?
3 lakh. Page 20, my lord.
Page
Page 20, my lord.
Yes.
Central scheme.
Is the central government a party?
Yes, my lord.
What does the central government say? Central government lawyer doesn't appear before this court.
Deputy Commissioner, my lord, is the chairman, my lord.
No.
Submitted representative.
Huh?
Deputy Commissioner is the, my lord, chairman of the committee.
This is by reimbursement, na? You first pay and then the reimbursement. Yeah. The MHA would issue the check in favor of the beneficiary. They would be sent to the district magistrate for further necessary as per the provisions of the MHA would examine the case in terms with the fulfillment of the MHA shall complete the process of the application within 3 weeks after its receipt from the district committee. And if the application is found to be incomplete, the mayor will communicate the deficiency to the district collector. Now, show me your application. Where is your application?
So, my lord, page 33, my lord.
Huh?
Page 33, and it's 9.
You are applying under the 3 lakhs and the Prime Minister Relief Fund is on the what? 2 lakhs?
2 lakhs, my lord, one relief fund is there for application, my lord.
What? And how do you get it?
Through Deputy Commissioner.
They give it. Under what policy?
In some cases. my lord. This, my lord,
Now, Mr. Have you forwarded this application? What have you done to this application? Who is paying for the Deputy Commissioner of Gwalpara? What have you done to this application? How the application is being made? Because The deputy commissioner forwarded to the disaster management. Isn't this the application? Who died? Who died? Aina Gupta. Taufikur Rahman, Mohidul.
It's 23 months, property cannot to be followed at the district level.
The instant writ petition has been filed by the petitioner, who is the wife of one Lipen Bosumatari, Lipen, L-I-P-E-N, since deceased. It is the case of the petitioner that the husband of the petitioner was a driver of a Tata truck bearing registration number AS18C 3941. The said truck was requisitioned on 23/2016 by the Deputy Commissioner of West Khasi Hills District in the state of Meghalaya. But why have you filed at in India, in Gwalpara? Huh?
From Assam, I claim it from Assam.
No, an incident happened out there. Why have you filed in Gwalpara? You should have filed under there.
Yes. For central, my lord.
Everything happened out there. Why should you file it in Gwalpara?
For central escape, my lord, I am, as I hail from Golpara.
Huh?
Golpara is my local district.
No. Why will these district authority, how can they decide? Tell me.
Yes.
They can't decide.
Yes, my lord, submitted all documents.
Was requisitioned by the Deputy Commissioner of West Khasi Hills District in the state of Meghalaya for transporting the operation team consisting of Meghalaya police officers and men from MLP and CRPF C-120 camp Tura. However, on 23/2016 at 2:30 p.m., the vehicle was ambushed by ZNLA militants, which is located on the outskirts of Bokchung village. In that regard, an FI was also filed before the officer in charge of Shalang, SHALLAND, police station, West Khasi Hills District. And on the basis thereof, a case was registered being under section 120B/302/326/323/34, read with section 27(1)(2) of Arms Act, as well as section 16, 18, 20 of Unlawful Activity Prevention Act and section 3 of the Explosive Substance Act. The petitioner, who is the wife of late Lipel Bosumatari, thereupon filed an application before the Deputy Commissioner Gwalpara in terms with the Central Scheme for Assistance to Civil Victims, public family of victims of terrorists from a communal and natural violence. Claiming an amount of rupees 3 lakhs as well as for another amount of rupees 2 lakhs from the Prime Minister's Relief Fund. The petitioner had also sought for an amount of rupees 5 lakhs from the Relief and Rehabilitation Branch of Revenue and Disaster Management Department of the Government of Assam. The incident happened on 21/3/2016. The relevant notification insofar as the amount claimed under the Revenue and Disaster Management Department is the notification dated 15/11/2014. The said notification, however, is very clear that the ex gratia which you would be paid if the incident occurs in the state, meaning thereby, if the incident had occurred within the state of Assam. Under such circumstances, the petitioner would not therefore be entitled to the benefits under the notification dated 15/11/2014. As regards the claim of rupees 3 lakhs under the Central Scheme for Assistance to Civilian Victims, public family victims of terrorist, communal and national violence, it is seen from clause 5 that the assistance to be given is an amount of rupees 3 lakhs. In the event of death or permanent incapacitation of the victim in a terrorist, communal or national violence. However, clause 6 stipulates the procedure to be followed at the district level. This court finds it relevant to observe that as the incident had happened, within the territory of Meghalaya and in the district of West Khasi Hills, the petitioner ought to have approached the district committee or even the district collector of West Khasi Hills. However, the petitioner has approached the deputy commissioner, Walpara. This court further finds it relevant to take note of that clause 6 of the said scheme, central government scheme, stipulates various verifications to be carried out. These verifications can only be carried out by the district committee or the district collector within whose jurisdiction the incident had happened. However, as admittedly, the incident, the incident, the Naxal violence, the incident happened happened within the district of West Khasi Hills in the state of Meghalaya. The petitioner ought to have therefore approached the district collector or the district committee seeking assistance as per the said central scheme. As regards the Prime Minister's relief fund of an amount, as regards the claim of the Prime Minister's relief fund of an amount of rupees 2 lakhs, it is the opinion of this court that taking into account that no scheme has been enclosed, showing as to how the petitioner would be entitled to, it would not be proper on this part of this court to make any directions in that regard. Accordingly, this court is of the opinion that the relief which has been sought for in the instant writ petition cannot be granted by this court, taking into account that the petitioner is not entitled to the relief in terms with the notification dated 15/11/2014 as observed herein above. And as regards the amount of rupees 3 lakhs in terms with the central scheme, as the petitioner has approached the district collector, deputy commissioner Gwalpara, and not the district collector or the district committee within whose jurisdiction the incident had happened, this court is not in a position to pass an appropriate writ. In a similar vein, as there is no material showed as regards the entitlement under the Prime Minister's National Relief Fund, this court is not also in a position to issue a writ. Accordingly, the instant writ petition stands dismissed. Be that as it may, this court makes it clear that a petitioner would be at liberty to approach the deputy commissioner, West Khasi Hills, or even the district committee of the West Khasi Hills to claim the benefit in terms with the central scheme. Then,
Regarding delay.
huh?
Regarding delay, my lord.
I've taken the liberty. I've given you the liberty, given the liberty. Okay. Grants the liberty. Who shall consider, and if so approached, shall consider the same in accordance with the provisions. Yes.
On the other time, status report was called for.
On the prayer of Mr. K. Goswami, the so leaves the matter after 2 weeks. In the meantime, shall obtain the status report regarding the investigation, particularly related to the state. Yes, what is your instruction?
Yes.
What are you asking for?
I am asking for fair and proper
investigation of the case, my lord. I am filing an FIR, my lord. It
To
is 90, my
conduct the free and fair investigation and expedite the investigation of Hatigao. Then
That is the case. File in 1990, my lord. So it is 2020, my lord. Page 19, my lord. That FIR is there.
why, what are you challenging? Say lead,
No one.
what?
I'm,
What is your, let's see the FIR. Where is the FIR?
FIR is page 90,
890.
90. Yes.
That case is at the, yeah. I purchased the plot of land. That is, 52 to the state report. Mr. Council, this FIR, why should this court exercise any jurisdiction? Why? You have 156(3). Why should this court exercise any jurisdiction? Tell me.
So you are praying for that.
Have you filed a suit?
No.
Then why haven't you filed a suit for cancellation of the deed of sale? Why? You are saying forced. File a suit. It's absolutely a civil dispute. And you are taking the help of under 226, thereby disturbing Mr. Talukar. Oh. My goodness.
That's not the way I was maintaining, but direct to expedite the investigation. That is only.
Why should this court direct? Tell me. Tell me, why should this court direct? Then when there is an investigation, a police case has been registered or not?
Yes, sir.
Now, if if it is not being done, you have a provision under the CRPC under 156(3). Have you moved there?
No.
Then nothing away. Mr. Talukar, if you have got the status report, then also you don't disclose. Yes. Nothing. These are very serious things.
Out and out civil dispute.
Huh?
This is out and out civil dispute.
Forget about the civil dispute.
And that.
He has to go before the 156(3). Why should this court exercise 220? Yes, there is something very serious. It is a case of a forged document. And you have not challenged this document also in a civil suit. This is a pressure tick. A writ being filed is very nice. Isn't it? High Court exercising jurisdiction, they may return you the money or not hand over the possession. Yes or no? Yeah. You move under 156. The instant writ petition has been filed by the petitioner, being agreed at the investigation so carried out in respect to the Hatigao PS case number 544/2020 and registered under section 417/468 of the Indian Penal Code. This court is of the opinion that taking into account the judgment of the Supreme Court in the case of Sakira Vasu versus, what is that it was say? Union of India, reported in 2004. What is Sakira Vasu's? You have got it? Very well. The Union of India versus Wales. It would not be proper on the part of this court to exercise the jurisdiction under Article 2 to 6 of the Constitution. That too when a remedy, an adequate remedy is available to the petitioner under section 156(3) of the Code of Criminal Procedure, 1973. In that view of the matter, the instant writ petition stands closed stands dismissed. Full stop. However, liberty is given to the petitioner to approach the concerned magistrate, a concerned court, in terms with section 156(3), if the petitioner continues to be aggrieved with the investigation so carried out in the above mentioned police Hatigao PS case number so and so. 11. Yes, what is this?
Supposed to argue the case.
Huh?
Mr. Alex Madhav is supposed to argue this case.
Who is supposed to argue the case? NS?
Alex Madhav.
Shall not settle the land in question by Khotian numbers when so in favor as per the area of. You are for whom?
Government, government.
Huh?
Respondent number 13
You are paying for whom?
1345.
1345.
Yes, sir.
Government.
Yes, sir.
Yes, why haven't you settled, given them under section 16?
Yes, sir. Still there's no instruction received.
Fantastic. Why? You want a matter of 2011 to get the instruction. 2021 too early. Eh? In some cases, we find that day I got one, Mr. Talukdar, I got one instruction. Even before the court issues notice that we have the instructions. Then why no instructions here? And I told them. Mr. Goswami was there, na? I told them, whoever the council is, I will keep this to show all other councils also that instructions come so fast.
Next up, exactly.
When?
Police.
Mr.
PK.
Appearing on behalf of the respondents, seeks for an accommodation. List the matter on 29/2023. It is observed that if no instructions are obtained, by then this court shall dispose of the petition on the basis of the materials available on it. Well, what interim is there? You are asking for settlement and what is this interim? Tell me. What interim is this? What interim?
Ordered at 3 to 2081.
Not to evict the petitioners from the land in question by Khotian number in the district. They are at all not getting the instructions. You are enjoying an interim order. You are enjoying an interim order. Mr. So-and-so, the learned counsel appearing on behalf of the respondents. In spite of there being an interim order, have not obtained instructions. They seeks for an accommodation for want of instructions. This court observes that by an order dated 3/2/2021, this court had directed that the status quo as regards the land be maintained, meaning thereby that the petitioner cannot be evicted as they are in possession of the land. The said interim order has been extended from time to time. But surprisingly, the respondent authorities are not interested in either vacating the interim order or obtaining the instructions so that the instant petition could be disposed of at the earliest. taking into account taking into account the conduct of the respondents, this court fixes the matter on 4th of December 2023. The interim order so passed earlier shall continue till the disposal of the writ petition. Well,
That's the lot.
yes,
Matter pertains to non-payment of existing amount fine.
you are entitled to.
Lot.
Under what provision?
In the notification matter, 15 November 2014 matter.
What happened?
Uh,
Died how?
This fund died.
Accident?
Accident. So,
When? Date,
13,
date of the incident?
13, 12, 17.
Oh. Report.
We have the instruction law. So there's the accident, police report is there.
Report. You have that instruction?
Lots.
Give it.
Lots.
Police report. Report. You are not issuing.
13 also same.
But in the 13,
It took 45 days payment.
because in that 13 lots, we don't have an instruction.
Huh?
In the next case, 13, we don't have the instruction.
Here you don't have.
In the 12, we have the instruction.
What is that instruction?
There's the accident, search it.
Give it here. And the other one is
13 lots. That is not.
same.
Same matter. Road accident.
There it will be 2 months. Here there is instruction 45 days, the other will be 2 months.
Sure.
Here there is an instruction for direction payment, there subject to verification.
Lot.
The other is 3 months.
Lot.
This 245.
Awesome.
14. Yes,
Matter pertains to lordship disqualification of director under section 1 of the company.
those are being agreed by the suspension of it. Has it become infructuous?
No lordship, it is
1 month is left
till
Oh,
30
till
30th of
October.
October. The period will over by 30th of October. No affidavit has been filed and my lord. There is a
You have been restored.
What?
Then what remains? Why have you been suspended? Why was it suspended?
My lordship, because of not filing of financial documents.
Have you filed?
No, lordship, that particular company was strike off. And we holding the position of directorship in respect of my lord, some other companies also. And therefore, my lord, we are aggrieved by the decision of the ROC, my lord, in my lord, deleting the names of our the directors in that is my lord, DI and director's identification number as well as DSC, digital signature certificate.
Hmm.
And in fact, that particular company that was strike off, my lord, we are not aggrieved by that striking of order. We are only aggrieved by lord by the my lord action of the ROC in my lord withholding our DSC and DIN. So therefore, we are
Why are you aggrieved?
not because unless it is restored, my lord, we could not.
No, understood. Tomorrow you may say, you may be aggrieved by the court giving you a jail sentence of 5 years. That can't be the reason. You have to say as to why you are aggrieved.
Lordship, because unless my
This is the consequence.
lordship,
The action must be bad for some reason.
lordship,
Why is it bad?
lordship, because my lord, the section, my lord, therefore, my lord, on the last occasion, my lord, in similar matters, my lord, we are praying for my lord, seeking amendment of our restriction. We want to challenge the proviso to section 167. Lord, that says, my lord, if I have been disqualified under section 164, my lord, not only in respect of that particular company for which we have been disqualified, but our directorship for all other companies shall be vacated. Or if we want to challenge that proviso,
So you, without challenging that provision,
Lord,
you have, is a case made out for an interim order.
lordship, in fact, my lord, there are two sets of restitution, my lord. One is, my lord, prior to that amendment has been brought to the, my lord, this Companies Act. It was in the year 2018, lord. So prior to that, my lord, also, my lord, similar petitions were filed.
And what happened to them?
My lord, challenging the same, my lord, the withholding of the, my lord, DSC and DI.
And my lord, after the amendment has been come, my lord, thereafter also we have challenged the paid action of the ROC. In fact, all the matters, my lord, the interim order was passed lordship by directing for the restoration of.
Give the list, we'll take all the matters. And first of all, why haven't you approved the NCLT?
My lord,
Not efficacious.
my lord, there is no.
The NCLT judges, they don't listen.
No, my lord,
Tell me.
in this matters, my lord, it is.
You have not challenged the provision. NCLT is okay, but how do you challenge? How do you ask all these things when you have not challenged the provision?
Lord, in fact, my lord, therefore, lordship, I am praying for my lord, some time, my lord, to file an application, my lord, for.
Huh?
My lord, I am praying some time, my lord.
For what?
We want to challenge this, my lord, proviso to section 167.
So you are challenging if you are challenging the proviso, you wouldn't this change the nature and character of the petition?
Lordship, in other cases that was.
Other courts are different and this court is different. How do you challenge? The moment you challenge this court, the jurisdiction of this court is gone. Tell me, isn't it, madam? The moment he challenges, the jurisdiction of this court is gone. Can he oust the jurisdiction of a single judge and bring it before the division bench by way of an amendment?
Lordship, even then, lordship.
We'll take it up at 2
Lord.
and further here on this.
But see, in this case, the period for disqualification is going to over in the month of October. Lordship.
Hmm?
In the month of October, their period for disqualification is going to over under section 144. So Lordship may make up the change in the meantime. And as per the interim order, their disqualification has been temporarily removed and DIN number is in activity. So they are not any difficulty. Formally, it will be over by October 1.
Where is the order?
Lord, lordship will find that page, lordship.
Hmm?
Lordship starts from page 21, Lord. Lord, it's the list. my lord.
List.
It is uploaded in the official website of the respondent number 2. It was uploaded on 12/2/2020.
Hmm.
It has been given effect from lordship 1/11/2018 to 31/10/2023. Your lordship will find it page number 23, serial number 380 and 381. They are the petitioners here. The
How
company
much?
was
What is the number?
380 and 381, page 23.
Then
It will be over in the October. Lordship. And
So?
by the virtue of interim order, their DI9 number has been activated. Lordship. And they were filing the return regularly.
Then
Formally, it will be.
you want to make it instruction.
Lordship, because there is no point in filing a PDP stage. And they are not at any difficulty at this stage.
Tell me one thing, on the basis of an interim order, the final relief has been granted.
Virtually.
Actually, the final relief has been granted.
No.
Now, you are not concerned.
No, Lordship,
For 2 years have passed by, you are not concerned.
no, Lordship, actually what happened in some other high court, passed different types of orders. In against order passed by the Karnataka High Court, Department has approached Supreme Court. That is also pending. And I have instruction that because the term of period is going to over recently. So they are not contesting and even.
No, if I fix it with a date, then automatically, and if it is done in the month of November,
Yes, sir.
then this code will be showing that this code by itself has made it in
In one way, Lordship,
isn't it? But would that be proper? If I fix it after
In a
the
strict
period
sense,
is over,
in a strict
wouldn't
sense,
that show that this court had made the repetition, had granted the relief and making your chance?
in a strict sense, lordship, it may not be proper.
Hmm?
In a strict sense, lordship, these things cannot be appreciated. But the peculiar facts and circumstances of the case, lordship.
There is no peculiar faction circumstances. The peculiar faction circumstances is the laxity on the part of the central government to file the affidavit.
No, lordship,
Can that be taken as a peculiar faction circumstance?
no, lordship, in this case, lordship, then I may produce that judgment of different high courts. In two high courts it held in favor of the department, and maximum high courts in favor of the petitioner. And even lordship,
Mr. S.C. Kyle, the learned counsel appearing on behalf of the ROC,
ROC,
appearing on behalf of the
That's what-
register of companies. Register of companies. Seeks for an accommodation of 4 weeks for filing the affidavit, list of the 4.
much.
Item number 17, that become infrastructure,
70.
Similar method.
similar method.
That period has already been offered. Lord.
The learned counsel appearing on behalf of the petitioner submits that in view of the interim order passed by this court, the petitioner have been allowed to use the DIN,
DNI number.
ESC and DI.
DSC and the DIN. And in the meantime, the order by which the petitioner's DIN and the DSC was struck off is already over. Taking into account the above, the instant with petition stands closed as it has become in.
Much.
Timing item 4.
Yes, no. It was filed on 29/4/2019.
In the court.
Yes.
Then what happened? 29/4 is the date.
Okay.
On that date, you have filed it.
2 or 3 days may be deferred.
So what is the date? Mr. N. Goswami appearing on behalf of the respondent shall apprise this court on 30/8/2023 as to what has happened to the final report dated
29/4.
29/4/2019. As he shall also apprise this court on the next date as to when the said report, final report was filed and as to whether the court had passed any orders.
All right.
15. Yes, contractual.
Lordship, component of materials being lost.
Yes, what is it?
Lordship, the video and chief executive officer already filed their affidavit, lordship, admitting the amount, lordship.
Video.
Video,
Yesterday, day before yesterday, I passed an order. That is the same time where BDO has said that, okay, but I have then also directed
Commissioner,
the commissioner to verify and make the payment.
similar.
Same. A order to Kumbhajan Louis too.
My lord, PNRD was a party in that particular case.
Hmm?
Lashkar Industries.
Last
Yes.
No, that is the same case. That is why I directed the commissioner PNRD to have a look.
Yes.
That was an amount something around 76 lakhs and one is 14 lakhs 90,000.
Yes.
I remember.
or amount is.
16, your case is 36 lakhs. Number 16,
I pray, Lordship, time.
4 months. I've given that 4 or 6 months, whatever may be, that is the same. 16. Yes, what is it, Mr.
The
Sharma?
matter here pertains to the withdrawal of the PSO which is assigned. to the
Huh?
petitioner. The matter was heard on 3 occasions, Your Lordship. Notice was issued on 8.
Setting aside the Intune WP message dated issued by the reserve Golaghat drawing reference from letter dated so and so. Mandamus will not be directing the director not to deploy a lot PSO for the safeguard of the petitioner. Oh,
Matter was heard, Your Lordship, on 3 occasions. On 8/4/2021, Your Lordship, notices were issued. When the then government advocate stated that there was no threat perception on the petition.
but the instructor matter was placed before the SRC, it was found that there was no first against it, and that we also left it be. Then,
Yes,
now you don't have a PSO.
I don't have a PSO. The issue here, Your Lordship, is that the PSO which was assigned to me was not by date of any government post or office that I held. It was by date of me being an investigative journalist.
Hmm?
Me being an investigative journalist. I'm a journalist. That is one of the reasons which has been assigned for the PSO which was assigned to me. The PSOs were assigned to me, Your Lordship, on the own volition of the government. Thereafter, in 2020, preferably due to the government change the dispensation of the political authorities that may be, a lot of PSOs were withdrawn at that point. A lot of PSOs were withdrawn. The petitioner PSO was also withdrawn. And the reason cited was on 8/4/2021 was that there was no threat perception. My humble submission to this court is that the situation that envisaged and led the government to put in the PSO, that situation had not changed. My submission before this court, I'm on a very narrow ambit here, Your Lordship, is that let the threat perception record be produced before Your Lordship's eyes, not to me to assess. It's a confidential document, and thereafter Your Lordship will pass an order. Because the matter here where I will stand is that the petitioner's locus has not changed one bit. He has had FIRs which have assailed.
Yes, Mr. Mazumdar,
That is my only
it's a very fair submission.
Submission is fair, but then just my first response will be, however, a threat perception which was there 2 years ago, 3 years ago cannot remain only because his position remains same. Threat person is different from his status. Anyway, madam, Paroy's comment has come and clearly stating that they have done the process and they have found that threat perception is not there. Lordship may just have a look. If necessary, we'll have to file an affidavit also. Okay, thank you. Lordship may kindly चलेगी
Mr. Sharma, tell me you fear whom?
Okay.
Whom do you fear?
I fear the accused that has been arraigned.
Oil India?
There are parties at play, your lordship, that is not. for me.
No, you're the people you have accused is Oil India
And your lordship, illegal mining.
or Hindustan Construction Limited.
And your lordship would see at page 29.
Uh.
There has been FIR at Kaziranga for illegal sand mining. The large mafia.
Understood. Against whom? Hindustan Construction Company Limited. Isn't it?
Some of them, your lordship.
No, these are the affairs.
There's a pleading given, like the list of FIR
No, your pleadings otherwise is very silent.
on the. that-
You say that
Yes.
you have lodged some FIR.
Yes.
Against whom? One is Oil India. Who is the Oil India? Let us see who is this Oil India. Managing Director of Oil India. He's going to do something to you. Huh? Chief Officer of John Energy Drilling, Bagjan Oilwell. Officers of Oil India responsible for blowout preventer arrangement.
But your lordship would see, bearing aside the threat perception report for your lordship, that there was a point in time when the threat process was considered clear. The lordship would also see that assessment report which warranted the threat. That report, your lordship, my humble submission of due respect to my senior, it cannot be read in isolation.
Huh?
It may not be read in isolation, your lordship. The report or the opinion of the state, which was formed in guaranteeing me and granting me the security at one point in time without even asking for it. That is my submission, your lordship. The submission, I'm not.
Now you see,
Yes.
for granting a PSO, there are three types of scrutiny. First is a report to be submitted by the officer in charge. Then there is a recommendation to be made by the DIG. DIG.
DIG admin.
Then the SRCC or something.
SSRC, man, States Security Review Committee. And they review my lord every 6
So
months.
wouldn't that be subjective?
That has to be subjective. In fact, that is not my submission, your lordship, that I'll go into the subjective merit of.
So when the authorities found it,
Yes.
they have not done it.
They have not done it, your lordship, and what I've been told by my learned senior with utmost respect, your lordship, that this report pertains to a host of other individuals also in this case will have been withdrawn. In fact, your lordship, the High Court of Punjab and Haryana in 2022, relying on a Supreme Court matter, had stated that security cannot be a static. And
Egon Luxon, yung video. Have a look at it.
Has become a now social status matter to have a PSO from the government. They can always, if he has personally anything, he can have his private PSO. Who is preventing him? This is government PSO what they want. And the government is very clear when they are withdrawing. They are in the process of withdrawing PSO from various officers who are enjoying it. And persons like him, private persons.
this subjective report, in fact, your lordship would take the matter. I would say my learned senior may not file an affidavit, your lordship would just go and have the time. Report the document also. Your lordship would take the matter for speedy disposal on a different date.
Huh?
Your lordship would take the matter for a speedy disposal on a different date, your lordship. Just go through the report.
No. First and foremost, you see,
Yes.
this court have not passed any order. So for the last 2-3 years, you have no PSO. What happened in the meantime?
Alive, your lordship, I'm alive.
Hmm?
I'm alive. I'm very much alive. That is not in dispute. Absolutely not in dispute. I'm not in.
Has there been any further development in the meantime? You have received any threats to your life? Because this is a case, I think instead of they filing an affidavit, you should be bringing on record something.
I give it to your lordship. In fact,
Because there is a no threat perception in the year
Yes.
2020.
2020.
Now
yes.
thereupon, has anything happened? The allegation, the FIRs which you have filed out here
Prior-
shows on the other hand, you are alleging against the managing director of oil.
yes,
Very well.
You're alleging complaints
The
against
threats has to be,
real and yes, absolutely. Your lordship cannot disagree with that.
It cannot also, like my learned senior said, not be.
Can anybody, just for example, a person threatening, okay, I'll dispossess you or else dire consequences, he can ask for a PSO? No. The threats has to be something to do with the interest of public interest also.
The individual,
Because this is PSOs are in public. These are government. Nowadays, you can always have private PSOs.
in fact, if lordship can dispose of the matter to that direction, that if you apply for a private PSO.
Huh?
If you can apply for a private PSO.
Private PSO, why should they direct? You can take from anybody. For security is there.
There are agencies.
The agency also,
Then why should I direct?
the matter,
You are always at liberty to take private PSO.
the lordship is satisfied, then
Hmm?
your lordship is satisfied, then I cannot accept the court.
No, here, from here, I can't say anything.
The threat was-
You see, this is subjective. And they have already taken up not one level, two levels and the third level. And they did not find.
And they do this exercise matter by collecting inputs from various sources.
Because PSOs is a way, at one point of time, PSOs used to be paid, given. A person files a writ petition, you get a PSO on payment.
In any way,
But
change-
you see, the problem arises is a PSO has to be a government servant. Or has to be appointed to the affairs of the state, which involves not only that initial, only the salary for that period. After you don't want, what happens? The burden lies upon the state for all time. So everybody will ask,
for the private.
the lordship-
okay. Heard the instant writ petition has been filed by the petitioner, seeking a direction upon the respondent authorities to provide allot a PSO to the petitioner for his safeguard. A PSO to the petitioner. From a perusal of the writ petition, it appears that on 24/10/2017, on the basis of a communication issued by the Additional Director General of Police Security, Police bracket Security, a PSO was deployed to accompany and secure the life of the petitioner. However, on the basis of a WT message dated 29/12/2020, issued by the Reserve Officer, Police Reserve Golaghat, the PSO so assigned to the petitioner was abruptly terminated. The petitioner thereupon submitted a representation dated 29/12/2020 to the Superintendent of Police Golaghat for assigning a PSO. As there is a threat to his life. However, as nothing was done, the petitioner submitted another application on 30/12/2020 Full stop. As the respondent authorities did not take any steps pursuant to the representation so submitted, the petitioner approached this court under Article 2 to 6 of the Constitution. Mr. D. Mojumdar, the learned Additional Advocate General, Assam, appearing on behalf of the state, have placed the details, placed certain instructions. We'll keep it on record. Place certain instructions issued by the place and instructions issued by the Superintendent of Police Golaghat to the additional senior government advocate, enclosing therewith the minutes of the State Security Review Committee meeting held on 10/11/2020, the list of protectees with existing security details of Golaghat district, along with the comments of the SP, comma, the recommendation of the DIGP bracket CR, comma, recommendation of the PRG, as well as the decision of the SSRC. In the said instructions, the representations so submitted were also, and in the said to the said instructions, the action which was taken on the representation so submitted by the petitioner can also be seen from a communication so issued by the Superintendent of Police bracket DSB Golaghat to the Deputy Inspector General of Police CR, as well as the representations which were submitted by the petitioner. From the said instructions, it further reveals that the deployment of a PSO to an individual is a collective decision. The process starts with the assessment being made by the Superintendent of Police on the basis of threat perception of the protectee to the officer in charge of the concerned police station. Thereupon, recommendations are made to the range of DIG, who in turn again vets the recommendation of the SP, and after that, he forwards the DIG forwards it to the SSRC with his comments. The final decision is taken by the SSRC. Therefore, taking into account the decision-making process, it is apparent that the same is based upon the subjective satisfaction of the officers on the basis of the threat perception. In the list of protectees with existing security details, which has been enclosed to the instructions, the petitioner's name features at serial number 16. And as per the field inspection assessment so carried out, it was found that there was no personal threat to the petitioner. And as such, it was recommended for withdrawal of the protection. This aspect of the matter was agreed at the level of the DIG, which was subsequently approved by the SSRC. Taking into account the above documents, materials on record, this court is of the opinion that no writ can be issued, thereby directing the respondent authority to allot oblique assign a PSO to the petitioner. This court, however, observes that if that the petitioner would always be at liberty to approach the respondent authority for assigning a PSO if there is any threat perception to him, and the authorities concerned shall also duly take note of the same and take action as deemed proper as per its extent rules. With the above, the instant petition stands disposed. The instructions so placed by Mr. D. Mojumdar, the learned additional advocate general, is kept on record and marked with the letter X.
In place of that extent rules, we have a SOP that what we can.
As per the extent,
SOP.
18.
Develop.
yes, what is it? Huh?
Otherwise, is entitled for enhanced ex gratia lordship.
Enhanced.
Lordship.
Why?
Because of the 2013 there is an
Certification lordship.
Huh? Ex gratia under what provision?
for extremist.
Extremist.
Lordship.
How much you are giving
Initially 1 lakh.
now?
Subsequently, it is 3 lakh. Lordship. 3 lakh.
But why is he asking for 4 lakhs?
2% that lordship. 2% that lordship.
Huh?
2% that.
This is done under which one?
Enhancement lordship.
Huh?
Page 30.
Page?
Page 30. Enhancement.
No, under which scheme?
Alert, I'm sorry. Alert, I have the respect not paid.
Huh?
The amount has been paid.
Paid. The learning council appearing on behalf of the petitioner submits that the relief which has been sought for by way of the instant writ petition have already been granted to the petitioner, and as such, nothing survives in the instant writ petition. Accordingly, the instant writ petition stands closed.
I'm
20.
50. This is the 50 and above.
Lordship.
The instant writ petition has been filed seeking a direction upon the respondent number 3 and 4 not to issue any license for operating new fair price shop by curtailing the existing customers of the petitioner fair price shops in terms with the order passed by this court dated 13/9/2013, passed in WPC number 5312/2013. as well as for a direction upon the respondent number 2 to dispose of the representation dated 2/8/2020 and to comply with the communication dated 9/11/98 before issuing any license for fair price shop in the operational area of the petitioner. This court, taking into account the relief sought for, finds it relevant to refer to the judgment of the Supreme Court in the case of Sarkari Sasta Anaj Vikreta Sangh, Tahsil Bemetra and others versus the state of Madhya Pradesh and others reported in 1981 4 SCC 471. In the same judgment, the Supreme Court observed that the fundamental rights of the traders, like the petitioners therein, who were carrying on fair price shop to carry on business and foodstuff, was no way affected. It was observed that the petitioners therein could carry on trade in foodstuff without hindrance as dealers. Only they could not run fair price shop as agents of the government. It was observed that no one could claim a right to run a fair price shop as an agent of the government, and all that person could claim was a right to be considered to be appointed as an agent of the government to run a fair price shop. Paragraph 11 of the said judgment, being relevant, is reproduced hereinunder. Taking into account the above observations made by the Supreme Court as quoted herein above, taking into account the observations so made by the Supreme Court as quoted herein above, it is the opinion of this court that the petitioners have a right to carry on the business of a fair price shop on the basis of the license so issued. The issuance of further licenses by the respondent department would depend upon the administrative exigency as well as also on the basis of the as well as also the National Food Security Act 2013 and the rules framed therein under. Under such circumstances, issuance of a writ as has been sought for would be would not be in the interest of administrative exigency, and more so in view of the mandate of the National Food Security Act 2019 and the rules framed therein. Accordingly, the instant writ petition is devoid of any merits, for which the same stands dismissed. It is, however, made clear that the respondent authorities shall, before issuance of any license, take note of the viability of the petitioner's fair price shop.
Yeah, please go ahead.
Hmm.
Lordship, this petition has been.
Yes, yes, central government.
Lordship, yes, that-
What is it? The central government is not, no, nowadays doesn't appear in the matter. I will be passing next time, keep on passing orders. Central government is not represented in spite of this. Because there were 2, 3 matters I couldn't finish it up today because of the central government's not being there. You are also there, Mr. Gogoi. What is wrong with the central government?
Allotment of cases, Lordship, that's why we. We'll take
It is very serious when the central, there was one matter. What was that matter? Only because of the central government that matter couldn't have been done. It was a simple matter. I couldn't finish it off just because of that.
We take care of.
I have been given only 30 matters, 13 admission matters per day, 30, 35 matters. And these 35 matters has to be finished that day. Should not survive for the next day unless for some extraordinary reasons.
After we take care.
Tell me.
Lordship, in this case, it deals with the pecuniary jurisdiction of the debt recovery tribunal. Because as your Lordship is aware, as per section 1(4), the central government has the power to fix the pecuniary jurisdiction of the debt recovery tribunal.
Hmm.
So as per the act, it was initially 10 lakh, it was there. But thereafter, by a notification issue, which is Annexure C, a gazette notification, the pecuniary jurisdiction of the DRT was enhanced from 10 lakhs to 20.
Annexure C, page.
Page, your Lordship will find page 47. On 6th of September 2018, and 48 is the relevant
Will not apply where the amount of the debt
second para, it has been stated. here.
ought to obtain extension and their being found. Okay, then
Now, this particular order was challenged before the Rajasthan High Court by a writ. So on 26/9/2018, this was stayed.
Hmm.
Thereafter, it was dismissed on 1/7/2019.
you are challenging 50, page 50.
Yes. Now, what happened, your Lordship, during this intervening period, when the
So any amount, any matter less than 20 lakhs has to be before the civil court.
Civil-
Okay,
Now,
then-
what happened? There was a stay for a particular period by a division bench of the Rajasthan. Now, during this period, this particular case, OA, on 12/3/2019 was filed by the respondent number 2 before the DRT. They were claiming an amount of rupees 13 lakhs 28,000 something. Now, we filed a WS taking the specific plea that by the circular, this DRT ceased to have any jurisdiction with regard to 13 lakh. It has to be transferred. Thereafter, in the meantime, while it was pending before the DRT, this particular order was, the stay was vacated. And thereafter, a second circular was issued by the state central government.
Hmm.
The gadget notification also.
Which
That
one?
is Annexure D, page 49.
Yes.
Yep.
Then,
Here it said that before the notification, if any case were pending, it was a clarification of the earlier notification. Those would remain, but after the notification has been issued, those cases will have to be transferred to the civil court. Now, what happened?
this is in Hindi, page 49.
Page 50 is the,
Yeah, what does it say? Let us read it. In exercise of the powers of so and so hereby make the following amendment. So in the state notification after the words is less than 20 lakhs occurring at the end of the following shall be inserted. But shall continue to apply to the debt in respect of which an application for recovery has been filed before the debt recovery prior to
Prior
the
to
date
the
of
date of
notification. That
so
is the
prior to 6th September, whatever is there, it would be remaining in DRT irrespective of the announcement. Now, what happened?
So
Our
if
case,
13 lakhs was filed prior to that,
subsequent,
subsequent to,
the notification of September 6 September 2018. It was filed on 12/3/2019. That is subsequent to the first notification enhancing the pecuniary duty. Now, what happened? A circular, once the Deputy Secretary of the Government of India issued the circular, Annexure E. This is the impugned. Your Lordship will find at page 51 is the typed copy.
okay,
Page
then,
51 is the typed copy of Annexure E, and the circular which is circulated to all DRTs. This is issued by the Deputy Secretary. Here they say he overrides the second notification, saying that whatever matters were they filed during the pendency of the case before the Rajasthan High Court shall remain with the DRT. Now, we are aggrieved by this because he cannot be a central government, a Deputy Secretary. It is not a gazette notification. He comes with a second clarification. After the first.
wait. Let us see, what was the first notification?
First notification, your
It is
Lordship
of
will
6th
find
of
page 48.
September, 6th September, 6/9/2018. Then it is, minimum is 10 lakhs.
Initially, it was 10 lakhs.
No, that was
it was
minimum is 10
enhanced to
lakhs.
20 lakhs.
So this is the minimum of 10 lakhs has to be there. Then only,
Now it is 20 lakhs.
Mr. Biswas,
The
kindly
minimum of 10
listen.
lakhs, yes.
You have been dealing with the matter for long. I have seen this matter now. So for that, give me 2 minutes also.
Yes, Your Lordship.
So on 6/9/2018, 10 lakhs was the amount.
Yeah.
Minimum. So
Minimum.
below that, it has to be before the civil
Civil.
court. Now what happened thereafter?
On 6th of September, it gets enhanced to 20 lakhs.
When? Where is that notification?
This 48, page 48, Annexure C,
48 says 6th of September.
6th of September 2018.
What does it say?
Second
20
line, whereas the central
No, prior
government.
to that, it was 10 lakhs when the act came in.
Yes.
So till 6th of year, it was made 20 lakhs. Okay. And then,
Then writ petition appears to have been filed before the Rajasthan High Court where it was.
no. When did they file? The
They
suit?
filed it on 12/3/2019.
12/3/2019.
19.
13 lakhs.
13 lakhs 68,000.
Okay, 13 lakhs, 68,000.
Now, we take a plea with regard to the
Proceeding
jurisdiction.
filed. Okay, then this notification was stayed by
A division bench of the Rajasthan High Court on 26/9/2018.
26/9/2018, stayed.
It was stated
Then
that the writ petition was however dismissed on 1/7/2019.
17/19
2019.
dismissed. So stay gone.
Stay goes, Your Lord.
Okay, then
After the notification of this order was the dismissal order was passed.
11/7.
11/7/2019,
Hmm.
a clarification order of a
This
gazette.
is not a clarification, it's a notification.
It is notification.
Why you are saying it to be a clarification?
Because they say it is a,
Where?
they say, means they add to it. In the
Where
sense,
is it? No clarification.
page 50, Your Lordship, means the second gazette notification,
It's a
Explaining-
notification.
second, page 50. It
Yeah,
is
it's a
gazette
notification.
notification.
Why you are
dated
saying to be
11th of
clarification? This is an amendment.
Yeah, amendment to the
In the
extent we can say,
notification after
because
the
20
word,
lakhs is there.
let us see, the central government hereby makes the following amendment to the notification dated so and so, published in the Gazette so and so. Meaning thereby, the moment this is dismissed
Yes.
on 1/7/2019, the notification dated 6/8/2018 comes into action.
Yes.
Now, what they do, they further amend it by inserting these words.
These words, they say
But
that
shall not continue to apply to the debt in respect of which an application for recovery has been filed before the debt recovery tribunal prior to the date of this notification, that is to say the 6/9/2018.
approximately.
So they amend it.
They amend it by saying that whatever cases were filed prior to 6/9 would remain in DRT, but any cases subsequent thereto, after the notification comes, when it was enhanced, will have to be shifted to the civil.
Okay.
The word prior is there, Your Worship. Prior to 6 September 2008.
So you say the note by otherwise, if it is made 20 lakhs, then many of the matters will go out,
Many of the matters.
which has happened out here in the high courts,
Yes.
which we should also learn while amending. Now, for that, they have now taken up that all those matters which were filed prior to the notification, which were less than 20,
Will still
will
remain
still remain, but above 10
above that.
still remain, because 10 was always the threshold.
That was the threshold limit.
Now, thereupon,
This deputy secretary,
he has issued this.
he issued this, or making amendment, means additional
So you are challenging the clarification.
this clarification, because
Now, how can you clarify which goes against the amendment?
I mean, that is what we are.
So you are challenging this. Yes.
Lordship, we have filed an affidavit, Lordship. In page 72, Lordship, we have clarified it, Lordship.
Yeah.
Page 72, running.
Ah.
In order to clarify all the queries and doubts raised by the various DRT regarding the fate of cases which were filed in various DRT during the stay period 26/9/18 to 36/9/6/2019. Opinion of the Ministry of Law and Justice Department, Legal Affairs, including as to whether the cases have suit valued between 10 lakhs and rupees 20 lakhs, which have been filed before the DRT during the stay period, shall be transferred to the civil court, and whether the state cases be transferred to the civil court. Thereafter, Lordship, we received, yet thereafter this clarification has been given.
Understood. But can you clarify something which goes against the act?
Lordship, because of that period only, that remains, Lordship. Other,
Whatever may be, you have come up with a notification.
Lordship,
Not an, it's not a notification. It is an amendment to
amendment to
that.
that notification, Lordship.
It's an amendment
Lordship.
to the act.
Yes,
Because the wording is,
No, no,
As the-
isn't it an amendment to the act?
yes,
it is an amendment.
It's an amendment to the act.
yes,
So that amendment says from 6/9/2018,
Lordship.
the jurisdiction of the tribunal would be from 20 lakhs.
20.
However, one thing was left out, that in the meantime, what has happened in the meantime? Earlier things which were filed before 6/9 would otherwise go away.
Good.
So this subsequent amendment was brought in by inserting that.
Yes,
Now their amendment remains.
remains.
Now, by way of a clarification,
Because of that stay period.
no,
Lordship.
understood, but because of the, by way of a clarification, can you amend the act? Not possible. Serious thing.
I am for the bank.
I know that. But can you amend by way of a clarification? Very difficult. It is something like
Like
an executive instruction, you're amending
in
that.
the act.
That is what.
You can't even amend the rules. Forget about the act.
Because of the clarification queries by the DRT's, Lordship, that clarification has been given.
Maybe, but then also you can't do that, no?
That period of stay, your lordship created the whole problem. Now
And
we
they may have to come up with a separate amendment.
amendment saying that this will of course also cover.
Covered it.
That has to be brought in. If you don't bring in, there is no way out.
Is there. That is it.
That's all.
That's that.
So we have to set aside this.
Lordship.
Any judgment?
Your judgment with regard to the stay of, what happens during a stay. That is there, your lordship. Now
Chamunda Moped.
this is chemicals, Panoria chemicals is there.
Yeah.
With regard to that status quo ante has to be maintained when there is a stay operation with regard to any notification. Once it goes, status quo ante will have to be restored. So this notification, the subsequent clarification again goes against that because the clarification cannot
A
override.
clarification is an executive instruction.
Yes.
So
That
by
is-
way of an executive instruction, you cannot override the act.
Override a amendment that is there. So I didn't, there is no as such, because he had cited a citation in his objection. Affidavit.
That regarding lordship operation
Where?
of the stay.
Huh?
Page 73, lordship.
Page 73.
That with Chamunda moped he had cited.
Church of South India.
Chamunda
Chamunda
Mopeds,
The staying
94.
And
Yeah,
because of
Chamunda
that,
Moped. While
And considering-
considering the effect of an interim order staying the operation of air, distinction has to be made between quashing of an order and the stay of the operation of the quashing of an order results in the operation on the date of quashing of the date of in the Because otherwise, what you are saying, if we admit it, would you not be saying that you have given the jurisdiction of this court but to this court? Or even the Rajasthan High Court to confer a jurisdiction upon the DRT by giving a stay? Wouldn't that? It would mean the same thing.
Yes.
If we are saying the stay, if there is a stay, you can allow to file.
File.
That means the court by giving a stay has conferred a
given the
jurisdiction, which is absolutely within the realm of a legislature.
But ultimately, your when stay will be there, you will operate your way. Then we will have no option other than to go to the
Civil court.
forum. So not civil court. since
No,
you-
I understand. You have to go, but the only thing is whether it would act, whether similar provision of 31 is there. 31 says what?
31 says any matter which the DRT has the power to look into. The civil court will not mean section 9 of The CPC has been taken care of by.
No, I think 30. See section 30, what does it say?
Section 18 is the bar of jurisdiction.
No. Section 31 or 30.
Transfer of pending.
Ah.
Transfer of pen-
31, your Lord.
31 is.
I remember.
Now, here.
Now, whatever matters were pending in the civil courts above 10 lakhs could go to DRT by operation of law. But is there a vice versa?
This was vice versa.
Now, would you apply vice versa?
That is
Oh.
not there.
Huh?
Nihar Industries explained this particular, there was a confusion with regard to that. At that point of time, when it was the city, 31, this act came into existence. Nihar Industries, your lordship.
No, understood. But I'm only saying whether it will operate vice versa. Because what will happen to the limitation?
Limitation obviously because of the prolongation section, this court may have to condone the delay because
Now, how can this court condone the delay?
that means that it will be a
That
litigation.
proceedings is not before me.
No.
How can the
Section 18
court
will
condone
come
the
into
delay?
play, your lordship, with-
Huh?
Because the court had accepted it. DRT had accepted it at that point of time. So Limitation Act will condone that because it was not willfully, they were pursuing the matter before the DRT, which did not have the jurisdiction. So once this notification, clarification is read down by this honorable court, that particular provision of the Limitation Act will come into play when they transfer the matter to the civil court. Your Lord.
14.
That
That
you
will
will have to, your
automatically
lordship,
come
again
into.
file your lordship.
Before.
That if.
Mr. Botaku will take it up on Tuesday.
Yeah.
The reason why I'm not otherwise concerned, this point is very simple. I'm only concerned about the limitation. This has a far-reaching consequence. Because 31 does not work vice versa.
No.
If 31 does not work vice versa, so by operation of law, these proceedings won't get transferred. Now, under section 12 is what? 12, I think, Limitation Act,
Yes.
not 14. 14 is what? I think 12. A limitation act only.
14.
I think 14.
Now, where is it filed in the
Other
proper?
Proper forum means due diligence, which,
No, 14 is what?
that is the.
14 is different. I think it will come under 12. It is a very important aspect which needs to be looked in. Excusing 14.
14.
In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or an appeal or revision against the defendant, shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, for defect of jurisdiction or other cause of like nature, is unable to entertain. Now, the problem is otherwise very simple. When the problem arises is, here they say a court. Now, can you say the tribunal to be a court?
The definition.
Then how do you bring 12, 14? You just find out that, because that is necessary. Like just for example, there are many cases, writ petition. Writ petition order is not a court. So you don't get the benefit under 14. Although there are many cases we gave, that's a different thing. But technically speaking, it won't. Because this order will have a lot of ramification in respect of Pan India.
Yes.
We'll have it on, you just,
Lordship, on Thursday, Lordship.
Tuesday I will.
Tuesday, I will also not be.
Okay, list the matter on 31st. 31/8/2023. At the top of the list, the final report.
Obliged.
Twenty-two. Mr. Pathak, that matter. Permanent local adalat,
Yes, sir.
there the interest will be from 110 only. It would not be from 16. 120 days will be over from 110 only, because the first part of regulation 18 says that the payment has to be made within 120 days. So from the date of payment, it will, from the death of the person concerned. So and the second portion of that says from the due date, from the date on which the payment is to be made. So the interest has to be calculated from 110. So I passed the order saying that the interest will be this much from there to there, and then 1,50,000 and plus on interest. I have not calculated that, but I am giving you 60 days time for payment of the amount. And I have asked the petitioner to submit what we call the bank details.
Very good.
Yes, what is this?
Hello. The board has raised some assessment bill. What assessment bill has been raised upon the one assessment bill on the ground that we have misused the meter, misused the electricity. Unauthorized, but unauthorized.
Then
And they have raised the bill. Actually, incident was that. All of the petitioner family member was there outside. Our house was closed. When they returned back to house, they found that there is no electricity in the house. And thereafter they called the mechanic called, found that electric meter had been, seal of the electric meter has been removed. Someone has removed the meter. They thought that there may be some steps, etc. That was not found. Ultimately, they called upon the electricity company. They call upon linemen, etc. But nobody comes down. So ultimately, the private electricity, he just connected the meter. On next day, petitioner went to the electricity office of the APTCL and informed that my meter has been, someone has removed the seal of my meter and it was disconnected. At that moment, they started to say that you are a thief of electricity. You have committed theft of electricity. We have disconnected the electrical supply to your premises and you have reconnected with unauthorized. So here question is that if electricity board is connected, how we can, we do not know. Either they have to serve a notice about disconnection. That has to be served. And secondly, our premises was closed, our house is closed, compound wise closed. How you come and enter there without presence of any person? Can you disconnect it? We do not know. At least after disconnection also, they should have sealed it, but they did not seal. It is open. So if our person can know that it has been done by them, and very honestly, the person next day went there, informed them. Instead of appreciating them, they called him very badly. They called him repeatedly call him thief, and thereafter raised a bill. Instantly they have raised the assessment bill of 1 year. 1 year assessment bill has been made, and has been directed to pay it instantly. Either you pay or we are not going to connect your supply. The person is having difficulty, no overhead water. Children try to prepare for examination. So somehow he has managed and paid it. Again, they have served, again, another bill has been served upon him. Same amount bill, again served upon him. Pay the bill or disconnection. So you are not there, my lord, questioning that. Whether this disconnection is lawful. Firstly, without serving any notice of disconnection, you have disconnected. First. And then the bill has been sent to us. Bill has been sent to us. Bill was, due date of the bill was 17th of February. It has been sent to us 22nd of February. Actually, bill should have been sent at least 10 days prior to the due date. But it has been sent 4 days after the due date. And thereafter disconnection. That is
No, you have been issued the provisional assessment bill
provisional assessment bill.
and then,
Then disconnection is also illegal.
no, it's okay. First, you have been issued a provisional assessment bill. The provisional assessment bill has to be finalized,
Provisional assessment bill actually
has to be, you have to be issued a notice
give
as
us
to
full
how it
notice.
is to be.
proper notice, but notice has to be given along with the provisional assessment bill. They have given a notice subsequently, firstly, we have to pay. Then I don't need kindly see whether they have followed any procedure while issuing the provisional assessment bill. That has to be. No procedure has been followed. But for issuing provisional assessment bill, someone has to inspect the my premise. Firstly. One officer has to inspect it. He will inspect it. After inspection, he will prepare report. Report will be, inspection will be in our presence, not in my absence. Inspection has to be in my presence. But nothing has been done. Then report will be given to me for signing. Consumer will have to sign the report. If the consumer refuses to sign the, they will affix it in a part of the house and they will take photographs. So nothing has been done. And how they have calculated the amount? How they have calculated the estimate amount?
Yeah, have you replied to the provisional assessment bill?
Hello. He has written letter dated 26/2. At that time, actually, instantly, he has to pay. The petitioner has to pay.
Understood. Have you replied to that? Have you replied to the provisional assessment bill?
That is, that one letter is there, 26/2/21.
And after that, have they made the final assessment?
That has not been made.
What has happened in this case is, facts are this, that for the months of January and February 2021, the regular electricity bills of the petitioner were not paid. Because of non-payment of the regular electricity bills of the petitioner, his electricity connection was disconnected. Then he came to the office of the APDCL on 24/2/2021 and paid that amount. That amount was 6,194, which was he had not paid. So on that same day, the concerned SDE passed an order that his electricity connection should be restored. When the concerned lineman, he went to restore the electricity connection, he saw that the seals of the meter were broken and the connection had already been restored. The connection that we had disconnected was already restored
By?
by somebody in his house. This is the story he is now projecting, that somebody broke into his house, broke open the seals of the meter, restored his electricity connection.
No, understood. Everything is understood. But you see, you have made the assessment under 126.
126.
Now, once you do it on 126, you issue him a so-called.
We have issued, because there was an inspection, we issued him a provisional assessment bill along with the
Inspection under 135?
Because it's theft of electricity also.
You have done under 135.
135 is also.
Then what happened?
So since the assessment has to be done anyways under 126, even if it's a case of theft of electricity for assessment of the charges. So a bill was served upon him. Now under 126, your lordship, he has two options. Either he can accept the bill or he can file an objection against it. So the mode of acceptance is by payment of the entire charges which have been demanded. In this case, he has done so within the time period. So payment of the entire assessment charges means that he accepted the provisional assessment. So further proceedings, your lordship, stop there, your lordship. The provisional assessment automatically becomes final, your lordship. If I may take your lordship to 126, your lordship.
No, electricity.
Because otherwise he has only challenged.
Because that is what I am seeing here.
Yes,
There's nothing else. There later on, nothing was done.
yes.
That matter na I have disposed of. BD steel or I.
Release still.
Ah,
Release still.
there I had gone thoroughly into this
Yes, sir.
126 and 135. এখন নহয় এই মোৰ তাত আছে নেকি ইলেক্ট্ৰিচিটি কোনে ৰাখিছে হা হা Okay, now what is the matter for today?
So now he has not filed any response to our affidavit in opposition otherwise. So the fact says they are seated there. He has not rebutted. Now, once the provisional assessment has been done, the bill has been served upon him without any objection within the time period of 7 days. He has paid the provisional assessment.
But you have said you have to pay.
No, but he has an option not to pay.
You inform him not to pay.
But that is a legal right. your
No,
lordship.
no, legal right, but see, what have you mentioned out here? Let's have a look in your map. Have you mentioned that this is a provisional assessment? Where is it mentioned it is a provisional assessment? Where is it mentioned? How will you know?
And this notice is under repeal regulation.
Yes, at
It is under repeal regulation.
Page 21.
it is at page number 21. your lordship.
Yes, what does it say?
It says that this is the compensation bill served upon you, which has been assessed on the basis of so and so, so and so. Evidence revealed that you were directly or indirectly involved in the act of malpractice. You are requested to pay the assessment bill within 7 days from the date of presentation of this bill. Failing which the amount in assessment bill shall be treated as areas against you and a service connection may be disconnected as per section 126 of the Electricity Act. Now,
What do you say about number 3? 126.3.
the person who has been, person on whom an order has been served under subsection 2 shall be entitled to file objections if any against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing to such person, pass a final order of assessment within 30 days from the date of service of such order of provisional assessment of the interest charges payable by such person. It has to be read with 4, your lordship. 4 says, 126(4) says, any person served with the order of provisional assessment may.
Understood, but where have you mentioned that it is a provisional assessment? To me.
It is not there in the notice.
Then
Then your lordship, perhaps what can be done, I leave it to your lordship. Since he has paid the amount, the connection is restored now. He has the electricity connection. His
the best option which can be done is directing him to file objection
Yes.
against that. This will be treated as a provisional
Very well.
assessment.
yes, sir.
He will file objection and you decide there.
Very well,
That is the only
very
way.
well. We will do it.
That is the Mr. Sharma, that is the only way out. What you are saying, this court cannot.
Another thing, my lord, you kindly see that notice. Page 21.
That is what I am saying.
It is under repeal F. Repeal regulation.
How do you say so?
That is written here. The comparison bill is being served on which has been set on the basis of clause 58375 electricity supply code of related matter 2004.
Yes,
2004.
at that point,
Now
your
it
lordship.
is, no, it is 2004.
Yes, that is correct, your lordship. At that point, the 2017 regulations
2070 was there.
had come into force.
2020 says that it has been replaced, repealed. So it is under repeal F. It is nullity.
The proceedings cannot be a nullity. The act of,
Proceedings
his
are
act
not.
of theft, the inspection report still stands.
No, as of now, you have not passed a provisional assessment order also.
If this is not treated as a provisional assessment order.
Then
No,
pass a provisional assessment order.
very well. We'll do it.
Let him pass a provisional assessment order and you supply it to the reply.
Very
And
well.
if you
Very well.
satisfied, refund him the amount. That is the only way. This can't be taken to be a provisional assessment order.
This is not a provisional assessment order. This is a notice for payment. Yes.
And you have not issued the provisional assessment order.
Very well. We'll,
So whatever amount is there, if he is entitled to, you pay him with along with interest, no?
or he'll have to.
Because otherwise that will be unjust enrichment. He has taken this money, so 2021. He must have taken loan. The instant writ petition has been filed by the petitioner. challenging the notice number F small t ESD oblique APDCL dash oblique 2020 dash 2021 dated 24/2/2021. And the provisional assessment bill dated 24/2/2021 being bill number 9000911134 dated 25/2/2021, as well as for refund of an amount of rupees 58,616, which the petitioner had to pay pursuant to the said bill issued to the petitioner within the period of 7 days stated therein. From a perusal of the materials on record, it transpires that it is the case of the petitioner that the petitioner received some bills, the bills for the month of, for the period from 2nd of January, that the petitioner did not receive the bill for the month of December 2020, but for the month of January, he received an SMS on 21/2/2021. Wherein the due date of the bill was mentioned as 17/2/2021. On 23/2/2020, however, on account of the preoccupation, the petitioner could not pay the said bill. On 23/2/2021, the petitioner found that there was no electricity. The petitioner called some technician and found out that the line was disconnected. On 24/2/2021, the petitioner went to the office of the respondent number 2 to inform about the whole incident and also to make the payment of the bill which he received on 21/2/2021. The petitioner also informed that during the informed that the meter which was provided to the petitioner had certain broken seal. It is the case of the petitioner that the petitioner honestly and bona fidely had brought it to the attention of the respondent number 2. But instead, the respondent number 2 rebuked the petitioner. Subsequent thereto, on the very day, the petitioner was provided with, was served with the initial assessment bill dated 24/2/2021, wherein it was informed that the petitioner should pay the assessment bill within 7 days from the date of presentation of the bill, failing which the electricity connection would be disconnected as per Section 126 of the Electricity Act 2003. Along with the said initial assessment bill dated 24/2/2021, the petitioner was also issued a provisional assessment bill wherein it was mentioned that there was unauthorized reconnection by breaking the meter seal of an amount of rupees 58,616. It is the further case of the petitioner that the petitioner, out of great difficulty, could manage the said amount of 58,616 and paid the said amount on 25/2/2002 to 2021.
We paid in 24 itself. We had to pay 24 itself.
It is mentioned as 25.
Subsequently, they have changed the receipt by 25. That is our thing.
Oh,
Subsequently, they have changed the date of the receipt.
oh no.
But we have paid in 24 itself.
And it paid the amount on 25/2/2021. The petitioner thereupon on 26/2/2021 submitted an objection against the compensation bill as well as the bill dated 24/2/2021 to the subdivisional engineer, Patasil Electrical Subdivision, APDCL. However, there was no redressal to the grievance of the petitioner, for which the petitioner has filed the instant writ petition. It reveals from the records that this court, by an order dated 19/3/2021, issued notice of motion and further in the interim directed that the power supply in the premise of the petitioner shall not be disconnected. Subsequent thereto, by another order dated 9/4/2021, আগতে notice issue কৰা নাই দেই. By an order dated 9/19/2021 directed the matter to be listed for motion on 9/4/2021 and further directed that the issue power supply in the premises of the petitioner shall not be disconnected. Subsequent thereto on 9/4/2021, this court issued notice and the respondent APDCL was directed not to disconnect the power supply to the premises of the petitioner unless the petitioner defaulted in paying the regular bills. It appears from the record that on 21/6/2021, an affidavit in opposition was filed in the said affidavit in opposition. It was mentioned that the petitioner himself had accepted that he had failed to make payment towards the electricity bill for the period for 2 months, that is for January 2021 and February 2021. And as such, the electricity connection to the petitioner was liable for disconnection as per the rules. It was further mentioned that accordingly, the petitioner's electricity supply was disconnected on 23/2/2021. While denying in the writ petition, in the affidavit in opposition, that the petitioner tried to contact the lineman, it was further mentioned in the said affidavit in opposition that upon payment of the amount of rupees 6194 on 24/2/2021, along with RCDC charges of rupees 700, as his electric connection was in disconnected condition, the service connection of the petitioner was ordered for reconnection on 24/2/2021. It was only then it was only when an attempt was made for reconnection by the line maintenance staff, it was seen that the seal of the meter was broken condition and the electricity to the premises of the petitioner was already in running condition. Under such circumstances, an inspection team comprising of the subdivisional engineer, the assistant manager REV, and the senior meter reader visited the premises of the petitioner and found that the meter seal is in broken condition, along with the unauthorized reconnection of the electricity by the petitioner. An inspection report was prepared regarding the findings at the site. However, the petitioner refused to accept the inspection report. On the basis of the inspection report, an assessment bill amounting to rupees 58,616 was prepared for unauthorized use of electricity by the writ petitioner as per the provisions of the AERC Regulation 2017, and the same was served along with the notice to the petitioner on 24/2/2021, which the petitioner duly received. It was further mentioned that the petitioner had duly accepted the assessment bill and paid the said amount of rupees 58,616. And as such, there arises no grievances. And as such, the petitioner cannot agitate the said grievances before this court. Next, I've heard the learned counsels for the parties and have perused the materials on record. This court finds it relevant at this stage to take note of Section 126 of the Electricity Act 2003. Which pertains to assessment. From a perusal of subsection 1 of section 126, the said section being relevant is quoted here in below. Mr. Pathak, is that Bridhi iron has been reported?
Yes, sir.
Where is it? Any idea?
I'll just give you a lordship the citation.
Yes, just give it to
It
me.
has been reported.
And then I don't have to write much because this needs to be written out.
A 2022
Yeah,
Ford GLR 2000,
I got
200.
it.
2022 Ford GLR 200.
One 126 code কৰি দিবা হা? তাৰপিছত এই জাজমেন্টটো কথা ক'লো যে 2000 2022 Ford GLR page 200 or paragraph a perusal of the above quoted provision would show a paragraph 17 সেইখিনি পা লেখা আছে হা that the provisions of section 126 of the Act of 2003 would be applicable to cases where there is no theft of electricity, but the electricity is being consumed in violation of the terms and conditions of the supply leading to malpractice, which may be squarely fall within the expression unauthorized use of electricity. This assessment proceeding would commence on the basis of an inspection of the premises or the equipments, gazettes, etc., or after inspection of the unapplied. A paragraph 17 or Kikoleke did you? Therefore, from the above, it would be seen that the mandate, or in terms of the mandate of section 126 of the Act of 2003, the order of provisional assessment has to be served upon the person in occupation or possession or in charge of the place or premises in such manner as may be prescribed. Admittedly, in the instant case, there has been no order or provisional assessment so served upon the petitioner. The impugned notice dated 24/2/2000. The impugned notice dated 24/2/2021 under no circumstances can be said to be a provisional assessment order. Full stop. Further to that, in terms with subsection 3 of section 126 of the Act, the person to whom the provisional assessment order has been served has a right to file objections, if any, against the provisional assessment before the assessing officer, as well as also has a right of a reasonable opportunity of hearing before the final order of assessment is passed within the time stipulated in subsection 3 of section 126. However, in the instant case, there was neither any provisional assessment order nor any opportunity was given to the petitioner to file objection, as well as also of hearing to, which is the otherwise the mandate of subsection 2 and subsection 3 of section 126 of the Act of 2003. In fact, a perusal of the initial assessment bill dated 24/2/2021 even does not mention that the petitioner has a right to file objection against the same. Next. Though Mr. K.P. Pathak, the learned counsel appearing on behalf of the APDCL, submits that the petitioner, having accepted the bill and made payment, subsection 4 of section 126 of the Act of 2003 shall be applicable. And as such, applicable. In the opinion of this court, in level of look. In the opinion of this court, without the compliance with subsection 2 and subsection 3 of section 126, the question of the petitioner having accepted the amount by making payment would not arise. Full stop. Under such circumstances, this court sets aside the initial assessment bill dated 24/2/2021 as well as the provisional assessment bill dated of the same date. Full stop. The respondent APDCL authorities are directed to serve a provisional assessment bill, provisional assessment order in terms with subsection 2 of section 126 of the Act of 2003. Now, the respondent APDCL is given the liberty to serve the petitioner with an order of the provisional assessment within a period of 15 days, 15 days, full stop. Thereby granting the opportunity to the petitioner to file objection and as well as also a reasonable opportunity of hearing as is mandated under subsection 3 of section 126 of the Act of 2003. Thereupon, if the petitioner files objections, the assessing authority shall, after giving the petitioner a reasonable opportunity, pass such orders as deem fit pass such final orders of assessment as deem fit within the period of 30 days from the date of service of such order of provisional assessment. It is further provided that if the provisional assessment bill order of provisional assessment is not served upon the petitioner, should I give 30 days?
Very well, Your Lordship.
There is a reason why 30 days could do. It's not served upon the petitioner. Then the amount which have been taken from the petitioner, which the petitioner had duly deposited, be refunded to the petitioner.
Very well.
That is why 30 days.
Very well.
Be refunded to the petitioner. This court further observes that if in the final assessment bill order, if it is found that the petitioner is entitled to any amount, any refund, the same shall also be refunded to the petitioner by the APDCL authority. With the above the petition stands.
What about annexure number 7?
Huh?
Annexure number 7, I think it is duplicate second bill has been paid then of the same amount. Second bill of the same amount. After that provisional assessment bill, they have sent another bill of the same amount.
So we have already stated in our affidavit that when he had, since on 24th, a lot of things that happened. By the time he made the payment, Your Lordship, the system had been closed. So manual bill had been issued to him, Your Lordship, on 24th. So on the next.
But are you challenging that?
Yes, yes, I accept it.
Have you challenged that?
Then if they agree that it's by mistake, then it should also be fine. What is
At the line, last line. Before parting with the record, this court deems it proper to observe and clarify that the bill dated which one? This one?
annexure 70?
That the bill
24.
dated 12th of March 2021 of an amount of rupees 58,616 as per the learned counsel representing the APDCL is nothing but a continuation of the initial assessment bill, which the petitioner had duly paid on 25/2/2020.
23.
Yes.
my lord, that if the matter pertains to my lord, non-payment of my lord, additional aggregation amount of rupees 2 lakh, my lord.
2,25,000 होता है 2,25,000
Which one?
My lord,
For what?
my lord, initially that, my lord, there is a my lord, notification for payment of my lord, 1 lakh to the next of kin of the deceased person who has been killed by the, my lord, extremist. And subsequently, it has been enhanced to, my lord, 3 lakhs amount. So we have been paid to, 1 lakh have been paid to us, my lord.
75,000 paid
75,000 is paid to us. And the remaining, the 2,25,000 is remaining, that is required to be paid. And we have made an application, my lord, before the concerned deputy commissioner of Kokrada district. And that is on page, and my lord, on the, my lord, basis of the representation made by us, my lord, investigation has also been made out for a circle officer of the citizen. That investigation lordship will find is page 40.
So you are entitled to under what?
My lord, that is in my lord policy,
Which one?
page 33
page 33. My lord, already 1 lakh has been.
Today I have taken something, somewhere
Yes,
similar
my lord,
matter, na?
Similar cases have been disposed of, my lord.
Today I have passed.
today item 18 but he has already been paid
Huh?
in
Oh, he
item
has got
18,
it,
he
na?
has got the relief
And therefore he withdrew.
Have not been paid. My lord, my lord, just for a moment, lordship will find us that inspection report that has been made by the circle of my lord.
and in
I have-
page 33 the relevant portion page 34 last point point number 5 that is
In case the person killed in extremist violence prior to Iman, but whose relative did not apply for any appointment prior to Iman and had applied after Iman and may or may not have received the equity under number under 20 received the equity rather under 2004 notification. They shall now be given appropriate equity as per Iman, adjusting the amount already received if in and they shall also be entitled to be considered under the scheme. So this is it.
and
So you
this
have
is
received 1 lakh.
1 lakh.
You need another 2 lakh.
75,000 he has received.
75,000 I estimate.
Then you want 2,25,000.
Yes.
Agree. Disposed.
Obliged.
Mr. Nayak, you are there in Mr. Bhattaji's case?
No, I thought it be okay.
Who is there? Where is he? Call him. Yes, Mr. Bhattaji, your matter.
Item number 32 orders.
Yes, what have you thought about the proposal?
Proposal, my lord, is all right, but 13 vacations, they have left them.
Hmm?
40 years, certain vacations are there. That is, they have left them. That they have agreed, bring the word, during the vacation. That there are some other vacations, namely, but Puja vacation, then Bihu vacation, people, all them. I am pointing out that.
In which school does the child study?
Don Bosco, High School, Delhi.
Okay. Now you must be having a vacation calendar.
Yes, that I can probably, I can fund it. To at least to both the parties.
Huh?
To the code as well as the petitioner side, I can fund it.
Produce the vacation calendar
My lord,
of Don Bosco Dibrugarh,
that I can,
and then on the basis thereof, we'll work it out.
yes, sir.
What do you say?
No, what I point out is going to vacation. One day, one in each month. That is the second Saturday or fourth. Saturday. You can get that certificate.
Come from, my lord.
That will meet the order of the trial.
My lord, being a judicial officer, in fact, he used to have our duties on Sundays too, my lord. Those bail bonds and all, my lord.
No, I am not asking those. I am asking only the second Saturday and fourth. Or fourth.
Every month.
She is in Dibrugarh.
Earlier she was in Mongoldoy, so otherwise it was pliable. In the days he can come and he can return. Also.
Let them think over it. I am not asking too much.
My lord, my lord.
What I have given you, Lordship wants to consider to see Bosco calendar, that will not play. And my lord, September, June and September. He will be having exam. So I will not insist.
Let us get the calendar
Yes.
and you take the instructions what she is.
Sure.
This is the matter again when?
My lord, in a week's time, my lord, next Friday,
Okay. On first?
1st of September.
First. This is the matter on 1/9/2023, on which day Mr. D. Gogoi, appearing on behalf of the respondent, shall obtain, bring on record, shall produce the calendar of the Don Bosco School, Dibrugarh,
Yes. they will.
as well as also shall obtain instruction in to the suggestions as stated, suggestions so made by Mr. A.K. Bhattacharjee, the learned senior counsel.
Got it. All right.
What is the age of the child?
10 years. 10 years.
Class 5.
How
In fact,
how will
But if he is in class 5, then on Saturdays there will be classes.
it's okay, but is it your suggestion that the child has to come to Guwahati? And if that be so, how will the child come? The child has to be accompanied by somebody.
That's by the mother. And she will be having duties otherwise. That's the typical. And also I will have the instruction whether on Saturday they have the school or not. Because till class 4, I know, my lord, there is no school on Saturday. Classes on Saturday.
No, my
But
lord,
in-
let me make it clear. If it causes difficulty either for the work or for mother, I will not.
My lord. I
We'll
will have
see
the-
only
yes,
that.
Yes, I will convey, my lord.
Let's get the calendar.
24.
Lordship, in this case, Lordship,
Hmm.
petitioners prayer for converting the uses of the house, Lordship, from commercial, residential to commercial has been rejected by the authority, Lord. And they are running a Vivah Bhavan from that house, Lord.
Huh?
One Vivah wedding marriage hall, Lordship.
Oh,
So that.
From where?
Against that rejection
what
order.
Viva Bhavan is this?
Jaga pe koi diyo.
This Viva Bhavan causes a lot of traffic jam.
Hatigao, Lord.
Eh?
Hatigao.
Where is it?
Otherwise, it will be covered.
So, what I-
Monisha Viva Bhavan.
Yes.
Where is that?
Hatigao.
Happy
So, Lord,
Now by in time order, they are running
status quo is there.
of the possession of the RCC buildings shall be maintained by the parties as on date. Status quo as regards only possession. But you are running on the basis of the status quo order.
Look, in fact, super bypass there. In fact, there was an order from the appellate authority. Because
appellate authority held that the running of Vibha Bhavan in the land and the building is justified. As there earlier the permission was residential, therefore the appellate authority directed her to submit an application for
For
conversion of use.
from residential to commercial.
And then we applied and they rejected on the ground as earlier shown. The road width in front of the road is 8 meters instead of 9 meters. But the appellate authority held that well, when the building was constructed, that restriction was not. Therefore, the
Two
appellate
grounds were
authority,
there, Lordship. One, building was construction was permitted as a residential building, and the road approach to the building, Lordship, it is less than 9 meters. On those two grounds, Lordship, that permission was declined. Lordship. Against that order, they went before the appellate authority. Appellate authority set aside that order, Lordship. But the ground remains. That 9 meter road is less than 9 meters. That ground is still there. On the basis of the order passed by the appellant authority, they file an application for converting the use of the building lot from commercial to residential.
From residential to commercial, not
That is-
commercial to residential.
Yes,
Because
residential
was-
to commercial.
building was assessed as commercial method.
Huh?
Building was assessed as a commercial.
Assessment is always there with a stamp out there. Whatever shall not be violative of a.
So I'm not.
Lordship, what I'm submitting, Lordship, this matter last came up on 31/3/2021, Lordship. At this moment, Lordship, I'm also not having the brief, Lordship. I have already instructed the authority to furnish instructions as we get the present status.
You file your affidavit.
Not been done this sometime, not to get.
But what is this status for? I don't understand.
That is.
Are you disturbing their possession? No.
That is their possession is already with them, Lordship.
No, where is the question of disturbing their possession?
Possession, there is no.
No, they still the premises, immediately.
Huh?
They have to by appellate authority directed them to seal the premises. And
They have sealed the premises.
Yes, Lordship.
Ah,
At that
yeah.
point of time, several Viva homes were sealed.
And now?
now those were sealed, my lord, by the appellate authority.
Viva homes,
By the appellate authority, they have this seal. Then how is this?
No, appellate authority allowed the appeal.
No, but your prayer was maybe pleased to direct the respondents not to disturb the petitioner from running the Viva Bhavan.
Yes, my lord. In view of
But
the.
that is not the order passed here, interim order.
No, interim order, because I am, as per the appellate authority order, they seal it, and we have been, because that was holding that the running of Vibha Bhavan is justified by the appellate authority. And that appellate authority order attained finally. The appellate authority under the section 438, my lord, any order passed by the either a corporation or appellate authority is final.
So the appellate authority says that you can run the Viva Bhavan.
Justified, that was justified.
Show me
But-
that.
At page 26,
Page 20.
last paragraph,
23.
26.
Ah.
Therefore, while summing up, it can be said that the running of the Vibha Bhavan in the aforesaid plan, plot and building is justified. So it is ordered for desealing. State premises and directed the petitioner to apply before the commissioner got minister to change the use as per provisions of.
Okay. Mr. P. Naik, the learned counsel appearing on behalf of the GMC
Yes.
submits that he requires some time to file the affidavit. List the matter. When? How much? You're sure? Because otherwise nowadays I'm fixing it in the month of November.
In November.
November?
That is already.
List the matter on 6th of December 2023. In the meantime, the affidavit be filed by 23rd of November. The petitioner would be be filed by 20/11/2023, and the petitioner thereupon shall be at liberty to file their reply. to stop. The petitioners, the interim order passed earlier shall continue till the disposal.
25,
Go Gyan Foundation, Assam
please, Your Lordship.
Agriculture. Yes,
Kindly adjourn the matter. Kindly adjourn the matter.
Why?
To take some time.
no,
Take
madam,
instructions.
absolutely wait, yes.
Lordship, the matter has already become infructuous.
Right.
The petitioner was aggrieved by an auction notice.
Let us see the order. What
Even
are you
in the last
challenging,
occasion,
madam?
It was
Go
submitted that the
Gyan
order was cancelled.
Foundation. Oh, this
We are
Go Gyan Foundation files a lot of writ petitions, huh? Writ of Treasury cancelling the auction notice dated 9/3/2021 published by the respondent number 4. Mandamus directing the respondent number 4 to hand over the custody of the cattle to Pranjipal Gosala, animal welfare organization that are licensed and registered or authorized or so and. Okay, now what is this order auction notice of 9/3? Why you are saying it could be infructuous?
because the impugned order has already been cancelled. I
You
have
have
a copy of
cancelled
the
it.
same.
So nothing remains. It has already been recorded in 9/4/2021. Then also the matter is pending. Huh? The petitioner herein have assailed the order dated 9/3/2021. Have assailed the auction notice dated 9/3/2021, published by the respondent number 4. It appears from a perusal of the auction notice enclosed as very late. It appears from a perusal of the auction notice dated 9/3/2021 that the auction was to be held on
24th of March 2021.
24/3/2021. Good stop. Miss M. Kolita, the learned counsel appearing on behalf of the respondent number 4, Has-
All the respondents, Your Lord, all the respondents.
all the respondents submits that on 24/3/2021, the principal scientist and in charge and convener auction committee, FRC, Assam Agricultural University, informed that the auction of the cattle scheduled to be held on 24/3/2021 at 11:30 a.m. has been cancelled. The said notification is kept on record and marked with the letter X. Taking into account the above, nothing survives in the writ petition for which the same stands closed.
Highly obliged. Your Lord.
26,
Yes,
Lordship, in this case, Lordship.
these
petitioner-
matters all are coming from the exact date is 19/4/2021. All these matters.
Lordship.
After that,
Lordship, here, Lordship, the petitioner's prayer was paying his municipal tax in installments, Lordship.
huh?
Means paying municipal taxes on installments, Lordship. And that prayer was rejected by the authority. And here he is saying that he was trying to file one representation that was also not accepted by the authority. So it is lying like that lot. Most probably he has got the relief lot. In the meantime, he must have paid
None appears on the court timing is 4:30, na?
lot.
None appears on behalf of the petitioner on call. Mr. P. Nayak, the learned counsel appearing on behalf of the GMC submits that the petitioners petitioner sought for an petitioner sought petitioner had requested the authorities for allowing payment of the municipal tax in installment, which have been rejected.
Yes.
This court further, the learned counsel, Mr. Nayak further submits that there is an interim order passed on 19/4/2021 that no coercive measures shall be initiated by the respondents. Under such circumstances, the learned counsel submits that there is nothing which would justify the issuance of a writ in the instant case. Be that as it may, as the petitioner is not present today, this court fixes the matter on 13th of September. It is made clear if the petitioner is not represented on that day, the instant writ petition shall be dismissed for non-prosecution.
Right.
28.
Yes.
I am appearing on behalf of all respondents.
Hmm.
So, my lord, in this case, they are challenging the office letter dated 9/9/2020.
And they have made the secretary party.
Yes, my lord. Just my lord, I filed him. I must take out the name of the secretary. First of all, this may be.
What is this interim order you have got? Tell me.
So they have issued.
Yesterday I didn't do anything. The day before yesterday also
Yes, my
similar
lord, yeah.
matter had come. I didn't do anything.
Lord, granted 2 weeks time. You have granted 2 weeks time.
What is this?
Stay
The
of-
tender process initiated under NIT dated 2/7/2021 shall not be finalized in respect of so and so at so and so. What is this? This order has been going on for such a long time.
Yes.
Why it should not be finalized?
Petitioner here into the legal here of blood. But his
By the
father was
Mr. Dwyer, the initial contract of the license was under the catering policy of the railways, which was subsequently extended by 5 years, and finally it was extended with effect from so and so till Iman under the same policy of 2010. After the expiry of the said lease period on earlier occasions and the death of heir allowed the petitioner to run the heir. Later he had also directed to submit the succession surrender which he could not. Then further extension of the license here. Now, how do you have a right?
that is what blood is.
Heritable, heritable right
Basically,
to do business.
that has been the policy so far as small stations are concerned with the railways matter.
Understood. Does a right accrue under the 2010 policy for forever?
The apex court judgment of 2016.
That 2016, that was on
Let us
that
check,
circumstances.
See,
And that 2016 judgment further says that we are not touching on the 2017.
that is what blood is para 34 of that judgment. Persons who have been given this kind of opportunity to earn their livelihood, that should not be affected, but that was the basic. But in fact, I have documents to show Millard. Thereafter, Millard review petition was filed, which was rejected.
What is this wheelbarrow?
Millard, small Millard,
Yeah.
Millard, a stall on wheel, you can say Millard. That's
Ah.
for just moving.
I hope you have no objection if there is any other wheelbarrow.
No, Millard, my should be continued that way, Millard.
Go ahead, have another 2-3 wheelbarrows.
Yes, since the tender has been invited, my lord, then they will,
No, no, can we pass an order that without disturbing the petitioner, you can give many wheelbarrows?
no, my lord, as per disclose of GCC of 2010, 2017, question of transferring the license of the disease to his legal heirs without, it is not acceptable. In the moreover, my lord, in agreement also, in clause 9.4, 19.4 also, it is there, no.
When did I fix the earlier matter? Day before yesterday?
No
Yes,
date has
my
been
lord,
given.
same matter. 2 weeks.
Okay,
Two,
list
Lordship
us
granted
matter.
2 weeks time, my lord.
Okay, list this matter. That matter, what is the number?
3557 of 2021.
One later than.
The list, this matter
WPC number.
along with WPC number 3557/2021
Along with
on
I is there also.
on 12th of September 2023 for final disposal.
Oh,
Let-
problem.
One day either earlier or later, but 12 something.
No, no. Only the letter, date of the letter is different.
On
Content
14th
agreement
of
is same.
September 2020.
My lord,
The interim order so passed shall be is extended till that date.
but
29.
another thing is that when I like.
There is nothing more.
There is an arbitration clause, my lord, in agreement. Since there is an arbitration clause, it cannot.
You
be
want to
accepted.
go for an arbitration for in a respect to a tender?
Yes, my lord. In country agreement, it is already clauses there.
Anyways, I'll hear everything on 14th, 15, na? 14.
14th.
On 14.
14. Oblige, your lord.
29.
Yes, Mr. Sharma. You are also having similar problem.
It's different, my lord. This matter pertains to non-release of the security deposit of the.
Mr. Sharma, that matter which I have disposed of, 2010 policy, 2017 policy, what happened to those?
Writ appeal was filed, my lord. That order was not interfered with. They went to the apex court, my lord. Thereafter, they made a prayer that they should be allowed to come back to the division bench again for agitating some further grounds, my lord. Now, they have filed a review before the apex court. And apart from your lordship's judgment, my lord, there is another judgment by Honorable Justice Jothang Muama following your lordship's decision. It has also rejected the contention of the, my lord,
2010
vendors.
has gone.
Vendors that it is not permissible to extend the license anymore. In this case, the grievance of the petitioner is with regard to non-release of the security deposit of the petitioner, my lord. I've got some instruction, my lord. It says, my lord, that there was some audit objection with regard to the release of the amount, my lord, and probably he owes certain amount to the railway. So because of that, we could not release the amount to him. Now, probably the audit has been closed, my lord, but the instructions which I have with me, my lord, is not sufficient to file the affidavit in appointment. So I'm praying for some time, my lord, so that I can bring the latest position on record.
I remember another matter similar to this is there, where she was appearing, isn't it? And I was about to pass the order in your favor.
They had some time with regard to.
No. She
I
said
was
that
at-
don't
I
pass
was
the
at-
order in absence of my senior.
Yes.
Because the client would mind.
Probably I was not there. In fact, this petitioner,
No, somebody else was there.
this petitioner had filed 4 writ petitions on similar causes of action, my lord. 2 of them have already been disposed of. In the 3rd one, I filed my affidavit, my lord, last week, and this is the 4th one. Same issue, my lord.
And what has happened in those two which has been
In
disposed?
the other 2, we have released the amount. The 3rd one, my lord, we are ready to release, but he has not submitted a certificate.
NOC, they need
NOC is required for the
in-
petitioner side.
security deposit hours, they need a NOC from the contractor.
No, not an NOC, my lord. No claim certificate.
That is,
No claim certificate. That is mandated under the contract agreement, my lord. The moment that is furnished, we'll release the security.
Here also.
In that case, in this case, the facts are little different, my lord. I do not have the latest information, my lord.
No, but does it take for you 3 years?
My lord, I understand, my lord. I also lost track of the matter. To be honest, my lord.
No, this matter has come after 2 years, exactly 2 years.
First time after motion, my lord.
Yes.
My lord.
Why
I'm
these matters have been hiding?
a short date,
Huh?
short date.
Fantastic. Okay, 30 August.
It was short.
Too short.
At least 10 days, my lord. I'll come up with the.
Place the matter on 29, 2023. Mr. B. Sharma
Unfailingly,
Sub-
I'll get that.
shall file their affidavit by 14th of September 2023.
Unfailingly.
Worship, sorry, in the earlier matter 21, packet number 21, there was an agreement that may be copied. The Worship has fixed it.
Okay. I would have otherwise disposed it of only today, that matter, but the thing is, I think something needs to be touched on that limitation.
Because the
Because
protection.
tomorrow it may not affect you, but all banks will be affected.
Published.
30.
May I please input?
Yes,
And the department.
Who is
that
appearing?
Place the inquiry report lodged for the particular lodged with the transaction dated 14/8 and 2/8/2023.
yes, Corporation Department, I have asked you to produce some as to whether any inquiry as ordered by the order dated 5/5/2021 issued by the commissioner has been completed.
Yes, my lord, I have a copy of the report.
Give it to me. When I'm directed to hear the inquiry as to protect the 5/5.
The operative part is at page 151. Conclude.
In the light of the field and experience.
This particular report has to be read along with the letters dated 5th of May 2021 at page 93 and 94 of the writ petition. Post this letter, this inquiry.
I'm directed to state that the state Iman in the above writ petition has laid serious anomalies in the preparation and execution of a list of fields. Conduct proper inquiry into the matter, submit immediately within 12. Meanwhile, you are requested to maintain status on the implementation of schemes under the integrated mentioned in the writ petition.
Page 9.
Who are you? Who are you?
We are elected group members of the Panchayat.
My lord,
We-
his limited prayer is that this status quo should be removed.
What is
That's
my
his prayer.
case, Lordship?
His prayer is that his status quo should be
Cannot
removed.
be issued
but he can't.
commanding not to give effect to the improved communications dated 5/7/2000 Iman. And to allow the continuance sanction the approval in 50 numbers of Now, are these schemes which are given in this report, which have been found to be not in accordance?
Yes.
Here it says, in the light of the detailed field investigation and examination of all relevant records, documents, statements of officials, it appeared that the so and so have prepared the list of 53 numbers of INRM schemes without giving due weightage to the schemes approved by the GPDP and thus violating existing government guidelines.
Yes, my lord. My lord, actually, initially, if my lord has a look at the first stage of the inquiry report, initially 59 schemes were approved with concurrence of the Gram Sabha, and post that 53 new schemes were sanctioned without the prior approval of the Gram Sabha. That is in violation of the section 16(1) of the Manrega Act 2005 and the Assam Panchayat Act. So the subsequent schemes that were sanctioned were illegal as per this inquiry.
Now, he is asking
Hmm.
that these schemes
53 schemes.
which were found to be not in order
Yes.
to be allowed to be implemented.
Yes, my lord.
That
That's
is
his
his
limited
case.
prayer. Page 19 is his prayer. Page 19 is his prayer.
My case is that lordship, during the COVID period, 19, government has not permitted us to hold any meeting. So, elected group members of the area and with the help of the local to the area, submitted application before the then MLA who was the deputy speaker of the legislative assembly. With the request that scheme may be tested, submitted 77 schemes with the request that may be forwarded to the authority for approval. It was forwarded before the block development office. Block development officer, after verifying the scheme, found 53 schemes are received. And accordingly, it was forwarded to the deputy
Okay,
commissioner
then
for
let us
financial
do one thing. You file a affidavit, bringing on record this aspect, because without this, he has no chance of replying. Okay. Mr. Your name?
P. Handick, my lord.
P. Hendik.
On behalf of K. Kumar. On
What?
behalf of K. Kumar, Senior Standing Counsel, PNR.
On behalf of,
K. Kumar, my lord. Kumar Kumar.
he has given you a wakalatnama,
My lord, he has authorized me to
written,
submit maukhik.
Huh?
Verbal.
verbal authorization only. Then none appears for the corporation department on call.
PNR.
In spite of our direction, we'll ask the commissioner to be present. What do you say? Who appears? P. Hendik. Mr. P. Hendik appearing for the corporation department has placed the inquiry report as directed by this court by the order dated 14/8/2023. Taking into account the significance which may have a significance and its bearing in the litigation, this court deems it proper that the Panchayat and Rural PNRD department should file the affidavit, thereby enclosing the said report so that the petitioner is in a position to rebut to such allegations as stated in the said report. List the matter on 22/9/2023. The affidavit be filed by 15th of September 2023.
Obliged.
45, 44 and 45.
I have the copy of the.
Oh, yesterday's matter. You are the petitioner counsel. Okay. Now tell me, what is your problem? Let's not go into this trivial issue. Now tell me, what is your problem? You want Directions should not be issued to the respondent not to evict the petitioners from dark number so and so situated anywhere without following the directions in so and so so and so. So it is a simple case that there is a direction being passed by Justice Biswas that they will form a committee and look into your grievance. So without doing it, you should not be thrown out. That's all. Okay. Now, what is the second writ petition for? In 2017? Why have you filed the second writ petition? What is the prayer? Okay. A writ in the net shall not be issued to set aside and quash the office memorandum dated 10/1/2017. A writ in the mandamus should not be issued to the settlement for granting settlement occupied by the petitioner in terms with the guidelines dated 2000 which have been issued for settlement of land in favor of the petitioner residing in so and so. So you want the settlement?
Yes.
Now let us see what it is. It is informed that the undersigned had discussed the matter with the principal secretary, revenue and Iman and others. The undersigned had gone through some of the records available and also tried to ascertain the circumstances under which two reports have been prepared on the same date as the next instance. Whenever the factual report of the matter, you are requested to kindly pray before the Honorable Guwahati High Court to grant me another 2 weeks time to clarify the matter. Okay. Mr. Nath, you see, the matter is there is a judgment of Justice Biswas on 15/6/2017, wherein it has been mentioned 15/6/2007, wherein it has been mentioned. Let's see that particular observation. Kindly come to page 25. In view of the matter above, the writ petitions are disposed of with direction to the respondents, particularly the Chief Secretary to the government, to constitute an appropriate committee consisting of officers from concerned departments, including Forest and Revenue, to look into the matter and to suggest to the government the actions to be taken to resolve the dispute. So the dispute is what? What is the dispute?
The dispute is not that they have issued they have issued notices to the petitioners for eviction. There are 3 of the written notice.
You have some of the petitioners have been given Khiras Patta.
Yes.
Also recommended for settlement of different plots of land with some of the petitioners. The petitioners have been in possession of the restaurant and have municipal holdings and electricity. They are paying Fauza Bahani in addition to other taxes and insurance. The process of eviction also caused extensive damage to the property. Relegation stated that houses have been demolished without making any return to rehabilitation. Revenue code. Another notification. This action on the part has created an unusual situation because the city of within the city because it benefits the city. So some have been given Khiras Miyari Patta. Some are paying government revenue, housing revenue, penalty. You are having houses there which was assessed to the Guwahati Municipal Corporation. Some of the houses were demolished.
Yes, that's it. And some are still-
Huh?
some have been demolished.
Now you have again got back. Thereafter, you have been residing again. Nothing has been done. Now there have been certain attempts being made to throw you out. Isn't it? Now, in view of the non-compliance with this, you are taking the benefit. The respondents have not complied with paragraph 6. That is your case.
Another aspect.
Eh?
Lordship, there is another aspect also. If Lordship favors the order dated 1/11/21.
Where is it? Of this court.
Yeah, in 1767 of 2012.
Huh? Yes, 1/11/2021. Yes, tell me.
Lordship, while adjudicating, there is one issue has come up regarding if Lordship comes to the third paragraph, Lordship.
How much area of land the 15 petitioners are occupying by constructing their houses inside and outside the notified mark. Secondly, the details about proclamation under section 6 of the Iman and the so. The eviction report data submitted by the availability of suitability land in the vicinity of declared square. Yes. Then
One aspect, Lordship, whether alternative arrangement can be here to be evicted from that.
yes,
Well, there are two aspects, Lord. The person to the last order, on last date, my Lord has directed us to get the clarification from the chief secretary.
he has asked for 2 weeks.
Yes, of course.
That will look into.
Well,
Now come to the point.
And in the second petition of 2000.
What have you decided in your report?
So in the report, in fact, the report found that the occupation of some of the appellants are found to be illegal in the South Kalabaha Reserve Forest, because the reserve forest has been notified in 89. Some are within that plot, and as per joint inspection conducted on 8/12/2017.
Now,
The-
if it is a reserve forest,
It was
isn't it required that they have some right if they were prior to that too? When you declare, prior to declaration, there is some notification issued, if I'm not wrong.
Lodge.
And when the notification is issued, you take into consideration those aspects of the matter. Isn't it mentioned out there?
Lodge.
I think in the IFR, where you make a reserve forest.
Well.
So under such circumstances, have you done that before the 89? Because they say that they have been there from 1978 onwards. And that is why in 1/11/2021, this court had made it very specific and clear that these are the 4 things we require.
Gotcha.
Have you looked into that order? Or Mr. Barbujari did not apprise you,
Oh, no one. I have.
although representing for the chief secretary without having an authority.
That second affidavit filed by the chief secretary, everything has been made clear. It is only, my lord, on the strength of that affidavit, my lord, this honorable court, on an earlier occasion, was the query to the petitioner, we will want to file any reply. They, my lord, almost surrendered. And then they say, my lord, that they almost were of the view that they will, eviction is almost imminent, because they do not have any formidable right. Then, my lord, on the strength of the submission, coming from the petitioner side, that 1/11/2000, my lord, 21 order was passed. My lord, directing the authorities to find out if any other suitable land is kept. Because in the affidavit.
No, you have to, you see, they have been there for the last 50 years now.
It is there, my lord, they are in occupation, there is no.
No. 50 years, somebody is there. You can't just at the stroke of your pen throw them out.
No, therefore, this honorable court on the earlier round of litigation, my lord, that honorable justice Iswar order which my lord has just not it. The direction was, clear-cut direction was issued, my lord, that since my lord, forest department, revenue department, my lord, the DMDS, DMC authorities are also involved. So therefore, the chief secretary is in the head of the all the affairs, my lord, of the state. So under the my lord, chairmanship of the
Chief Secretary, my lord, a committee was, my lord, directed to be constituted. Now that committee was constituted, my lord, in the second affidavit, my lord, it has been, my lord, annexed. That committee was constituted on 19 September 2009. Then, my lord, nothing happened. It was a committee, my lord, which was constituted and it remained in paper. Then, my lord,
How many people are involved
in the committee,
total in this exercise of yours? How many people are going to be affected?
my lord, precisely the petitioner. The petitioner.
How many petitioners are here?
Here, my lord, here,
How many petitioners you are representing?
Lordship, we are reporting
How many petitioners? 15. So both the writ petitions are filed by 15 writ petitioner.
Yes. Petitioners are
Okay.
same.
Second is by six.
No,
Second,
Second one is by six. I'm sorry.
second petition is by six.
So therefore, an odd number of, my lord, about 20 families to be precise, 20 families will be affected. Now, if thereafter, my lord, during the proceedings of this honorable court, my lord, an order was passed whereby, my lord, is honorable.
Now, let us see the Assam Forest Regulation. It's very relevant.
Now, my lord, that committee was constituted and entire exercise was done. Field verification was done. And this affidavit, second affidavit, my lord, all the geo coordinates and everything has been annexed. Everything has been annexed.
Then
Then, my lord, there is a, my lord, what transpires from that report, my lord, that they, the petitioners, my lord, are in, my lord.
Mr. Barbujari, kindly see paragraph section 545 of the Assam Forest Regulation 1890, because you have done it in the year 1989.
My lord,
That is an admitted fact.
Yes, notification.
You have a copy of this?
no, my lord.
You give it to him.
section 6 of
No, we'll look into section 6. First, let us go to section 5. See, power to constitute a reserve forest.
Yes, my lord.
The state government may constitute any land at the disposal of the government.
A reserve forest in manner hereinafter provided.
Provided.
Then, my lord, notification by
It is
state
proposed
government.
to constitute any land a reserve forest. The state government may publish a notification in the official gazette
Official gazette.
specifying so and so. Then you see the proclamation
Yes,
where a notification has been issued under section 5. The forest settlement officer shall publish in the language of the area so and so in any portion of so and so proclamation, specifying as nearly as possible the situation and limits, setting forth, explaining the consequences which as hereinafter, fixing a period not less than 3 months from the date of so and requiring every person
my lord.
claiming any right or making any claim referred to or then mentioned in section 5 either to be present to such officer within such period, a written notice specifying or to appear before him within such period and state the nature of such claim. Now you see, this is, you may say that, oh, this is government land, they have no right. But the thing is,
This is now here, my lord, the admitted position, it is reserve forest.
it is not a reserve forest. They became a reserve forest in 1989.
Yes.
They were there in 1978.
Yes, that is their case, but my lord, yes, correct.
So, that is why I showed you section 4.
Yes, my lord.
The state government may constitute any land at the disposal of the government, meaning thereby it is a government land,
Yes,
or the government may acquire that land.
yes,
So it has to be at the disposal of the government. It can't be a private land.
yes, my lord.
So under such circumstances, the persons who have been referred in section 5 and section 6 would be persons who may be having an easementary right or a person interested,
My lord.
asking them to sue it. Now see the bar to accrual after proclamation.
Yes.
During the interval between the publication and of such proclamation and the date fixed by the notification declaring the forest to be a reserve as hereinafter provided, no right shall be acquired in or over the land comprised in such notification except by succession or under a grant or contract in writing made or entered into by or on behalf of the government or some person in whom such right or power to create such right was vested when the proclamation was published.
Yes, my lord.
And on such land, no new houses shall be built or plantation formed, no fresh clearings from so and so, so and so. Shall be deemed to prohibit any act done with the permission in writing of the forest or any clearings lawfully done for June cultivation by person in the habit of practicing such cultivation in so and so.
Meaning they were, once it is proclaimed.
You
once
cannot.
I cannot, but there is a case, they say, before proclamation, they were there in occupation.
Understood.
Yes.
So before proclamation, did you exercise, give them a right of hearing?
Yes, that's why my lord, the parent of my lord.
111. That's why the order dated 111 is recorded.
That is what I am saying.
So therefore, my lord, this aspect of the matter, since forest department is also a party here, my lord. Therefore, I was seeking the
You see,
assistance of.
two departments, forest as well as central government, very difficult to find out.
But if for a moment, my lord, for my satisfaction, if my lord takes up the affidavit, second affidavit, filed by the chief secretary.
Others may go. There's nothing else. Yes,
The second affidavit, my lord, filed by, my lord, it was filed on 17/3/2020 by.
There's a contempt is compliant.
Huh?
Item 31, there is a contempt.
Other side is there,
Is there.
complied.
Sir, the
What is the order date?
the order dated is 12/6/2017.
Passed in?
Passed is WPC number 5017 of 2014.
It's been complied with,
Applied by speaking order dated 4/7/2023.
speaking order dated so and so. And as such, the contempt proceedings can close. No, it's the speaking order. So produced by Mr. B. Gogoi is kept on record and marked with the letter X. X good. Yes, others may go.
Yes.
I'll be just here for another 10 minutes and then leave.
No.
Huh?
Item 40, we have some urgency in the matter. If I can be listed on Monday or Tuesday.
No, there's no urgency. What is this urgency?
My lord,
You are there for whom?
my lord, item number 49, that was fixed on the last date petitioner in person.
Which matter?
This is corruption matter, my lord.
Oh, that person.
Yes, my lord.
You are, what is your name?
Vikas Sharma. I have appeared
You,
on the-
you have appeared along with another person, na?
Yes, my lord.
Petitioner number 1 is not, you are petitioner number 2.
Yes, my
And there Mr. Nath is appearing.
lord. Yes.
Who is appearing for response number 6?
Now I have seen name is shown.
Oh, yes, 5. That is the problem. That has been corrected. Oh, you are appearing now.
My lord, I am personally present.
Oh, fantastic. And you are? 5. 5 is the private respondent. Have you filed your affidavit? When are you filing it? You have to file it because you are the person to be heard. Your name? Ms. N. Mahanta, the learned counsel appearing on behalf of the respondent number 5 submits that she needs an accommodation for filing the affidavit. List the matter again on 22/9/2023. The affidavit be filed by 15th of September 2023. And how will he give a copy to you?
My address was available. My phone number is available.
No. You are not a lawyer. That is the biggest problem. This court further takes note of that as the petitioners in the instant writ petition is represented by the petitioner number 2 in person. The respondent number 5 shall file the affidavit by serving and by giving an extra copy to the office of the senior government advocate, Assam, and the petitioner shall collect the copy from the senior office of the senior government.
Item 40,
Hmm.
for the 6 men,
Oh,
and the case was dismissed for default of lawyer. So
case with us. Any day next week.
I don't know, 40. Okay. No. Wait, seriously? Cost?
So it's got for lawyer, my lord.
So that is the cost upon the lawyer. Dismiss for default happens only because of the lawyer only, not because of the client. Mr. Mahmood, have you ever heard the dismiss for default on behalf of the client? No, no. 2006 matter. How many days?
Delay 2,482 days.
List the matter after 2. No, nothing. We may issue notice.
No, notice already sent or all of that.
Notice to whom?
Notice to the respondent 13th.
Okay, list the matter up to 1,000 days. Too much.
Next week.
No. 2 weeks. Yes, Mr.
That
Respondent by, you have filed this affidavit by respondent number 7.
no, my lord, it is respondent number 1. My lord, it is filed on 17/3/2020. It is by,
17/3/2020.
yes, it is by Kumar Sanjay Krishna, the chief secretary, as he was dead, my lord. In that affidavit, Lordship may kindly come to page 16. That is the report,
Page
page 16,
16.
16.
Yes.
My lord, I will slowly read it, my lord.
Hmm.
Kindly, my lord. Inspection survey report of at South Kalapahar Reserve Forest and adjacent to Jyotikuchi Village, Dispute Revenue Circle. The genesis of the inspection survey is that after observing some activities at South Kalapahar Reserve Sanctuary and adjacent to Jyotikuchi Dokingao Village under Dispute Revenue Circle, regarding boundary survey of South Kalapahar Reserve Forest was carried out by officials of Kamrup East Division and officials of Dispute Revenue Circle. As per direction of the Honorable High Court in WPC number so and so, this petition, the DFO Kamrup East Division wrote to the Circle Officer Dispute Revenue Circle by so and so data dated. Accordingly, the Circle Officer had fixed a date on 13/10/2017. Now the proceeding. The Circle Officer Dispute Revenue Circle fixed a date on so and so for joint verification. Accordingly, the following officials along with Circle Officer and his Lat Mandal staff were also present before initiating the survey works. The party concerned perused all relevant records, map and notification of South Kalapahar Reserve Forest and scrutinized it. We, the undersigned, have conducted a spot verification on 8/12/2017 in connection with above mentioned Guwahati High Court matter this case. And the findings are as follows. Accordingly, 0 coordinates of Sri Ratneswar Kolita and 14 others has taken during survey time, their place of occupation. During our physical verification, we noticed that most of the householders constructed permanent house of the said land. Then, my lord, number 1, 2, 3, 4. On researching in the fields just nearby South Kalapahar Reserve Forest, Pillar 10, we verified the revenue as well as forest map and found that some land in question in a reserve forest land under Kalapahar Reserve Forest was notified during the year 1989 by government notification number so and so. And subsequently, which was published in the Gazette notification on 89, having area of 70 hectares with well demarcated boundary description. In course of our field verification, we made see so and so.
No, Mr. Borpujari, you have said many things, but the fact that they say claim to be there at that point of time.
No, my lord, it is there. Therefore, I am reading the fact finding. There are other also, my lord.
Where?
On being, my lord, let me continue, my lord.
I read it.
Then my lord will come to the next page, my lord, page 17.
I've seen it.
Yes, these are the 15 petitioners, geo coordinates, their location, my lord, satellite location, whether they are inside the forest. Now, Lordship will kindly come, my lord. Page 20. These are the satellite pictures. Page 20, 21.
Some are outside.
Yes, some, my lord, my lord, that will be cleared, my lord, in the
No,
subsequent
from
report.
this picture at page 20,
My lord,
there are only how many people? 1, 2, 3, 4, 5.
yes.
The remaining are outside. 1, 2, 3, 4, 5 is outside. What about the another 5?
No, that is clear in a subsequent report by the deputy.
Oh, we have the forest department. You are there. Oh, forest is there. Very well. He's hiding out there. We can't see him.
Now, yes, now Lordship may kindly come to page 22. Page 22, my lord. I am troubling my lord with all these papers just to, my lord, apprise your lordship with the factual situation. My lord, this is that 1989 notification.
Hmm.
Lordship has drawn attention, my lord, to section 4.5 of the Forest Revenue Manual. Then my lord will kindly come, my lord, to page 30. This is most important. This is the report of the deputy commissioner, my lord, to the additional chief secretary.
Hmm.
Here, Lordship will kindly see, my lord, at page 31, everything has been discussed. In the light of all the above facts, the following become clear. My lord, got it, my lord.
Now, what is your basis to come at serial number 2? No encroachment of any claim right was made at that time.
My
What is your basis?
No enforcement or any claims, right, compensation was made at that time.
What is your basis? Unless you see the records of that acquisition proceedings, whether at the time of proclamation, whether those things have been done,
No.
whether there has been compliance to section 4, 5, and 6.
No,
That's it.
No, that has been discussed, it, my lord, here.
No, what? How could he do it when there is a, have you looked into the records of the proclamation?
No, Lordship will kindly come to, in that page 31 itself, Lordship may
Yeah.
kindly see, my lord, kindly come to that third paragraph.
Hmm.
Another meeting was held with regard to this case in office number of DC Kamu, which was attended by representatives of Forest Department, GMDA Circle Officer, where after threadbare discussion, it was unanimously decided to accept and approve the joint verification report. And cumulative concurrence
But
was.
all these happened in 2018. I'm saying about 1989. At the time of proclamation, did you take into account? Because those persons who were inside, how do you take care of that?
It is clear in the next paragraph.
Yeah.
Yes, in this regard, another contiguous report was submitted by the Divisional Forest Officer dated 2020, wherein he reiterated that enforcement by petitioner in question only took place after declaration of South Kalapaha Reserve Forest by government notification.
What is his basis?
So therefore I was submitting.
What is his basis to come in 2020?
Which was subsequently published in on so-and-so department conference. So
No, if somebody comes up and says that, okay, I know this, but there has to be the backing, because when there is a certain provision,
yes,
where the time of, whether the time when whether you have taken the recourse under section 5,
yes.
once you file, have you mentioned anything? Whether there was any objection, have you seen the records of the proclamation?
So therefore I was making that submission. Assistance of standing council forest will be. required.
There, we have it. There,
My lord,
standing council forest. For what? We need therefore the records of this. This will make it clear.
Yes, they are.
Whether at the time of declaration, because you see, the
Yes,
fact is very simple.
my lord is.
Once the
Absolutely, yes.
declaration has been made, you
Yes.
can't do anything.
Yes, yes.
They have to then take the recourse to the Ministry of Environment and Forest.
Yes, so therefore they have drafted the writ petition in such a manner that they came into occupation prior to 1989. It's a question of fact. Now it has been denied in this report, Lordship has seen, but
No, it's denied in this program. Where have you looked into it?
the excel is, so therefore, my lord.
This report which you are mentioning it at 2020,
Yes,
where he has said in a contiguous report,
my lord,
let us see that report whether it is there.
Yes.
Where is it? It does in the report out there, it is being mentioned out there that he has looked into the records of that.
so therefore, Lordship will direct the forest department to produce the records.
Nothing
Yes,
doing.
sir.
You have not produced it. What to do? You have not
My lord,
complied.
Lordship
Unless
will
you don't comply, you can't touch.
Forest department has filed two affidavits.
Understood, but Mr. Nath, kindly appreciate one thing. Section 4, 5, and 6 is a manner in which a forest, reserve forest is made, declared. Once it is declared, no new rights. If there was, because there are two other aspects. If there are some persons, the government may also relocate them or give them compensation so that this area becomes a reserve forest. Now you are thinking of making a reserve forest in some place, huh? Some hill to make it nice and beautiful. Okay, so similar to that, you have to do like this.
Well,
So there has to be some objection. If they have not filed their objection at that point of time. Meaning thereby either whether you have issued the proclamation, you have issued the notifications.
Yes.
Once you have issued the notification, if
yes,
they
yes.
don't file it, then they lose their right. This is, I think, how you have to proceed.
I am obliged to my lord because my lord had narrowed it down.
Why do we need all other
All
things?
this period of time, my lord,
Because
these are-
once it has been made
Yes.
clear,
Yes,
even the government of Assam today can't do anything.
yes, yes.
They have to take the recourse from the Ministry of Environment and Forest.
The notification of the forest issued in 68, that is required. That will.
Ah.
68, that will.
That notification on the 5 will require, and whether at that 5, whether there was any objection filed by them,
Yes.
whether there was a publication, due publication. If there was a publication, why didn't they do it at
It
that
was,
time?
it was.
Because your statement made is 2020 that these people have entered later on. That is your statement.
Yes, yes,
So whether that can be only presumed.
yes.
If there is no file and objection at that point of
yes,
time, then
yes,
the
yes,
presumption
yes,
is that they had nothing to do.
yes, yes.
And then it becomes a pure question of fact, which
Yes.
this court can't do anything.
Yes, of course.
It was in the.
Isn't it?
It was.
See, the short matter, long matter is short.
No, my lord, therefore I have, my lord, with all humility, I have submitted, I am obliged to my lord. But this aspect of the matter, time and again, my lord, we are happy. Because only that, my lord, 1968, Yakov still living. That's it.
In para.
Only find out that.
Yes,
Alone.
yes, yes, my lord has gone to the.
And he is the senior government advisor, he can get it.
Lord.
Like this, he is the chief secretary.
No, my lordship will kindly direct, my lord, the standing council for us, because they will be in a better position, my lord, to get hold of the
Okay.
record.
Matter.
Kindly.
When you are going to produce it? Not much. These are 2012 matter. Let us finish this matter before the chief secretary replies.
My lord. Lordship can immediately, my lord. on-
Because all other matters are trivial.
Yes, my lord.
Yes.
Now the next question is,
Yes, yes.
if they have to vacate. There is no way out. If it is a reserve forest, they have to vacate. Then the next question is, where do you rehabilitate? Because in a reserve forest, you can't keep them. That will be against the very Assam Forest Regulation or even the Environment Protection Act. So you have to rehabilitate somewhere. Complete. List the matter when.
My lord, can it be on, my lord, 7th of September, my lord, immediately after death vacation, my lord. 7th
Okay,
will be-
list the matter on 7th of
7th,
September,
Wednesday,
on
madam.
which date the learned council appearing on behalf of the Forest Department shall produce the records pertaining to the proclamation of reserve forest by notification dated. That notification you were reading, na?
Yes, yes, at 13th of December 68,
13th of December 1989.
1968.
No, this is 89.
68,
No, we are concerned with the 70 bighas.
it was the section 4 was issued in 68. It was in the Gazette notification on 2nd of April 1969. They were
No,
given
no,
hearing
the proclamation is issued when?
on 89, 25/9/1980.
25 years. Records pertaining to the proclamation made, proclamation dated so and so made in under the Assam Forest Regulation, Assam Forest Regulation. 1891, na?
Yes, 1989.
1891.
Yes, 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 yes.
Yes.
The date, which is 607, so what happened is that my senior Mr. M. Mother-in-law has expired.
Oh.
That's why he's upset today. It's exactly 14 days. but-
Okay,
Just-
we'll have it on then 12. 12.
Yes, sir.
12. Huh? And the matter be shown as part of.
But I am deeply obliged. sir. For you, make the passport.